Hmm? 33.
32.
It has come for orders. For what? Why it has come? Orders? Huh? LCR hasn't come. Okay. On the prayer of Mrs. H.M. Fukun, the learned counsel appearing for the petitioner, let the matter be listed after 2 weeks. After 2 weeks?
It may be fixed. Yeah, there is it.
September 10.
Apply.
May please also. But item number 20, the CD probably not there. I mean, interim mail. Item 20.
20 CD hasn't come. Mr. S. Botthagor is present for the accused applicant. CD is awaited. Let the matter be fixed on
Hmm.
11th September.
My interim mail.
Interim order so fast shall continue.
Everything is at about 31. From other system. The PCR has been received, madam. We have received the objection yesterday.
Hmm?
We need some time to push. That's the INR.
On the prayer of Mr. D. Bora, the learned counsel appearing for the applicant, let the matter be listed on 14th September.
May I please also. I have to mention item number 13 of the daily list. Bail hearing matter. Perhaps CD not received. I have request. This is from Sila Person.
CD is awaited. Let the matter be listed on.
28 Lordship can.
Let the matter be
behind the
listed.
28. Can it be on 28 Lordship?
28 what? 28.
Oh, yes. Of August. Because he is behind the bar.
28 is very difficult. On second.
Second. Highly blessed.
Hmm.
That the matter.
Hmm?
On it, enter with the TC petition. Any document.
34 you write LCR not received. Let the matter be listed on 11th September.
May it please your lordship, I beg to mention item number 15, my lord. I may be allowed to withdraw this.
15. Your name?
Yu Han.
Mr. E. Khan, the learned counsel appearing for the accused applicant, submits that he has instructions to withdraw the instant AV application. The instant AV application is dismissed on withdrawal.
That's 15 is the precedent.
Hmm?
15 is the precedent.
You send it back and the CD to be returned.
Another prayer, my lord, for listing of a bail application, my lord, as connected matter is fixed tomorrow before your lordship, my lord, as item number 41, my lord, arising out of same affair.
Nothing comes to Mr. P. Botthagor is application option. I don't need a month of October option.
Month of October. Why? Why so late? Out of station, he will be out of station for 2 months. Hmm? Have you intimated the other side? Who? Who is the other side? You have intimated the other side. Whom? Whom have you intimated? Okay. Okay. Ms. B. Uja, the learned counsel appearing on behalf of Mr. P. Bodole. Raised for adjournment of the matter for 4 weeks. She submits that she has already taken the consent of the counsel appearing for the petition. Let the matter be listed. Sometime in September last. 4 weeks, that's what, September 29, let the matter fixed on 29 September. Interim order so fast earlier shall continue till the next date of listing. We'll vacate the interim order. We cannot go on and go on like this if you do not do the matter.
May it please your lordship, in regard to item number 47 of supplementary list, I'm praying for calling of an additional affidavit that was filed yesterday.
47.
47. Lordship.
Additional affidavit for what?
additional affidavit, it was filed as a reply. It was filed as a reply.
Reply? What reply in bail?
It was, the extra facts were bought in,
Who bought an extra book?
the petition, the applicant,
You are appealing for whom?
the applicant, sir.
You're filing the additional affidavit, bringing in certain new facts.
Right.
What?
Right, Lord.
Okay.
Please, your lordship, I beg to mention item number 36 to the consent of the other side, lordship, the matter will be adjourned.
36. Your name?
Hey, the lordship, on behalf of Ms. Nawaz.
Right, on the prayer of Mr. A. Tarabdar, Parliamentary Council, appearing on behalf of Mr. S. Nawaz. Later matter will be listed. When?
Lordship, next week.
The matter will be listed on 7th September.
May it please, your lordship, I beg to mention daily list item number 17. Lordship,
Second
CD has
number?
17, CD has not been received.
CD is not there, but CD is awaited. The
Interim
matter
order
is
is
listed. On 26th, on 26th. 26th,
Lordship, interim is there, interim,
interim order so passed on this, I'll continue.
much obliged.
Item 46, for adjournment.
Well, Mr. A. Tarabdar, the learned counsel appearing for the accused applicant submits that he has instructions to withdraw the instant bail application. The instant bail application is dismissed and withdrawn.
Deeply obliged.
Item 1, also.
Please, your lordship. My lord, here the 483 application, my lord. 47 days in detention. Now the charges are under 305A, 324-4, which is and 3174, my lord. Habitually stealing property, my lord. But there is only one antecedent, my lord. The charges, my lord, against the accused is that he entered this Grameen bank and tried to open this cash vault. And upon inspection, the informant says that the CCTV is missing. But his name was not there, my lord. The co-accused have been granted bail by the learned trial court, my lord. 47 days in detention, my lord.
Who have been granted bail?
My lord,
Who are the persons who have been granted bail?
my lord, the co-accused, my lord, page number 35, my lord.
Now
Who
from,
Who were arrested with the accused here, the petitioner, they have been granted bail, my lord, by the learned session judge Kukra. Page number 35, my lord. Abdul Aziz, Rakesh Chaudhary, Kartik Bormon, my lord.
Well, the employer is concerned also, new name is been mentioned. So perhaps the role of the petitioner may be Not similar with.
But my lord, nothing has been found from my possession.
Stone might not be in the same philosophy. This stone might not be in the same philosophy.
What happened to other people? Amit Devnath, Kartik Bormon,
They have been,
Rakesh Chaudhary,
they have been granted bail, my lord.
where?
This is page number, my lord, 35.
35, who are these people?
My lord, this
Kartik
is
Bormon is there.
Joinal Abdin, Imanul Ali, Rakesh Chaudhary, Kartik Bormon, my lord. Relevant portion 37, my lord. They have been granted bail, my lord. Considering my length of detention, my lord.
Bora, you'll have to allow this. Heard Mr. A.W. Anand, the learned
Grateful.
counsel appearing for the accused applicant, also heard Ms. S.H. Bora, the learned AKP fellows to introduce an application under section 483 of the BNSS 2023 seeking paying for bail to the accused applicant. In connection with Fokiragram PS case number 26/2026 registered under sections 305 in bracket small a stroke 324 bracket 4 of BNS 2023 added section 317 in bracket 4 of BNS 2023. An FIR was lodged on 1/7/2026 by one Navajyoti Circular branch head of Assam Gramin Bank, Chitira branch, alleging before the officer in charge, Chitila Police Station, alleging inter alia that on 29/6/2026 at about 10 a.m. when he and other staff members entered the bank after the holiday, they found some unknown persons had unauthorizedly entered the branch premises through the back door during the holiday. Yeah, that the miscreants entered the premises by breaking the rear grill lock as well as the door lock and had attempted to break open the case vault but failed to do so. It was alleged that some documents had been misplaced from their proper place and two Godrej locks were found broken and the CCTV DVR was found missing. On the basis of the FIR, the police registered Fokiragram PS case number 26/2026 under the aforementioned sections. The learned counsel appearing for the accused applicant submits that the accused applicants are not involved in the instant case and they have been accused and he has been one person, no?
1%.
He has been arrested on the basis of suspicion, and he has the suspicion pushed up. He submits that the accused applicant has already spent how many days? 47 days.
47 days, my lord.
47
2nd of
days,
July.
47 days behind the bars. The further submits that the co-accused, some of the co-accused persons have already been granted bail by the Sessions Court, by the learned Sessions Court, Kukrazo. In view of the aforesaid, he submits that the accused applicant should be granted bail. MSS's Bora learned OPP opposes the bail prayer of bail of the accused applicants, submitting that there may be submitting that submitting that an investigation is still going on in the instant case, full stop. Taking into account the interfacts of the case as well as the detention behind the bar of the accused applicant, this court is of the considered opinion that the accused applicant should be granted bail at this stage. Accordingly, it is directed that the accused applicant shall be released forthwith from jail and furnishing of a bail bond of rupees 30,000 with the security of like nature to the satisfaction of the which court?
CGM Kokrajhar.
CGM Kokrajhar, Sultan Kokrajhar, subject to the following conditions, the accused applicant shall cooperate with the investigation and make himself available as and when called for. Accused applicant shall not tamper with the investigation in whatsoever manner. In terms of the official direction, the instant bail.
Grateful, my lord. Grateful.
Thank you. Not legal. What the 483 application, Lord? Their petitioner is behind the bar since 26/7/2026. As on today, my lord, for 24 days. Lordship will find the FIR page 9, my lord. Page 9. In fact, Lordship, yesterday the similar kind of case arising out of the same FIR has came up before your Lordship. Anticipatory bail application. That was anticipatory bail application. And Lordship was pleased to grant the privilege of anticipatory bail to one of the main accused, Lordship, in whose account money was transferred. And the petitioner before your Lordship. Kopil Roy. Petitioner before your Lordship is a Topon Roy, and he was arrested, my lord, on 26/7, soon after lodging of the FIR. And till today, he is behind the bar. The amount has already been refunded, my lord. 10,000.
These are all this thing, I mean, MD, whatever. What was the name?
MD Associates, that is the
MD Associates.
Lordship, the pending EMI collection agency, my lord.
You have yesterday's order? No.
Lordship, that is not uploaded, my lord.
Not uploaded. I don't know why it isn't uploaded. Always we sign it, then it doesn't happen. After morning it gets uploaded.
Lordship,
Actually, they upload 5 o'clock. Last uploading at 5 o'clock. So if we signed that the copies also, we stay till 9 o'clock. We sign it, but like still it is not getting uploaded. We'll get the upload copy only in the morning, 10 o'clock.
Lordship.
So that is the way the system works here.
I do have the bail application number, my lord, the AB number 1905, my lord.
Okay, we'll allow him. Mr.
P. Das, Lord.
P. Das, the learned counsel, appearing for the accused applicant, also heard Ms. MS Bora, learned AP for the state. This is an application under section 483 of the UNSS 2083, which is paying for granting bail to the accused applicant in connection with TUPS case number 26/2026 under section 309/4/115/126/111 of BNS 2023. An FIR was lodged. An FIR was lodged on 25/7/2026 by one complainant named Mohammed Bilal Ali, alleging inter alia that before TU police station, alleging inter alia that on 15/6/2026 at around 10:30 AM when the complainant reached at Natkusi Chowk, the accused persons, namely Kapil Roy, Dipu Das, Ekman Roy, and other 2 persons of MD Finance Associates, Natkusi, forcefully snatched his motorcycle bearing a registration number AS 15U0753. It is alleged that on 16/7/2025, the complainant deposited an amount of 5,000 on PhonePe and another amount of ₹5,000 in cash to the accused person, namely Kapil Roy, but the accused persons did not return his motorcycle. When the accused, it is alleged that when the complainant went to the office of the accused persons to collect a motorcycle, then the accused persons beat him and snatched another amount of ₹30,000. On the basis of the FIR, the police registered TUPS case number 26/2026 under the aforementioned section. The learned counsel appearing for the accused applicant submits that the main accused person, namely Kapil, has already been granted anticipatory bail by this court on 17/8/2026 in AB number 1905 stroke 2026. He further submits that since the accused applicant has already spent 24 days
24 days.
behind the bars, the accused applicant should be granted bail at this stage. So he full stop. And on the other hand, on the other hand, MS since the APP has proposed the bail pair of the accused applicant full stop. Taking into the entire facts of the case and his detention behind the bars for 24 days, this court will consider the opinion that the accused applicant should be granted bail accordingly. It is directed that the accused applicant shall be released forthwith from jail and punishing of a bail bond of rupees 20,000, which is security of like amount with the satisfaction of the
CGM Nalbari.
CGM Nalbari subject to the following conditions. The accused applicant shall appear before shall cooperate with the investigation and appear before the investigating officer as and when required. The accused applicant shall not try to another clause they talked about. In terms of the opposite direction, the instant bail application is disposed of.
Obliged, Lord. Deep level.
Chalo, temporary,
This is second bail application, Lordship. Earlier bail order is at page 36. Here in this case, Lordship, the present petitioner was implicated on the basis of co-accused statement, Lordship. And while earlier bail application was rejected, he did not receive that copy of that under section 207, Lordship, that police papers during trial. So now he has received, Lordship, all those copies I have annexed here also. From it appears, Lordship, his state.
We'll call for the CD. I mean, this is the charge sheet matter. Charge sheet matter. Please let the TCR come. I heard Mr. Ajad Ahmed A. Ahmed, the London Council appearing for the accused applicant, also heard as MSSH border and AP for the state. There is an application under section 483 of BNSS 2023, paying for granting bail to the accused applicant in connection with special NDPS case number 44/2025. Arising out of Karimganj case number 221/2025, registered under section 22 in bracket C/29 of NDPS Act 1965. Call for registered to call for the TCR from the TCR of special NDPS case number 44/2025 from the court of the learned. Which court?
Special Judge Sribhumi.
Sessions from the court, learned court of session just Sribhumi. Scan copies. Then you write, let the matter be fixed on. 10 September.
May I clear one thing, Lordship, that
Hmm.
TCR along with the case diary, Lordship, because the accused person who implicated me, their statements were recorded twice. So why it was recorded twice, that I will reveal, Lordship. TCR along with.
TCR along with the case then.
Lordship. Obliged.
May I please your lordship? My lord, affair is case 10, my lord. Here, my lord, the informant case is that he, my lord, executed a deed, my lord.
Read it FIR.
My lord, I am reading, my lord, the case 10, my lord.
What is your name? Usman Ghani.
Yes, my lord.
Who is this Jahanuddin?
My lord, Jahanuddin also, my lord, what happened, my lord? Osman Ghani, the present petitioner, is the relative of Abul Kalam.
No, who is this Jahanuddin?
Jahanuddin also, they're the same village man.
Hmm.
What happened, my lord? Regarding the possession only, his affair is lost, my lord. In fact, my lord, he did not mention who is the owner and where, my lord, they have executed, and, my lord, how the money was taken. And the present petitioner is the relative of the accused number 1 in the affair.
No, whatever relative. I mean, you have taken money and like, I mean, you have
No,
not,
my lord.
you have
My
not.
lord, very unfortunate, my lord. The present petitioner is no way connected, my lord,
Hmm.
because it is a whole case is civilly national, my lord.
Your
Just
name,
15
your name is Usman Ghani.
Osman Ghani, my lord, I am the relative of Abul Kalam.
Abdul Ghani.
Yes,
Relative
my
of Abdul Ghani.
Abdul Ghani and yes, my lord. He did not know my
Okay,
full name.
heard Mr. M.U. What is your name?
Anuddin, ma'am.
Anuddin, the learned counsel appearing for the accused applicant also heard S.H. Bora, the learned APB for the state. This is an application under section 482 of BNSS 2023, praying for granting PRS bail to the accused applicant in connection with Matia PS case number 63/2026 under section registered under section 120B, 120 capital B stroke 420 stroke 406 stroke 506 of IPC. The allegations in the FIR dated 16/6/2026 filed by one Rajat Ali before the officer in charge Matia police station that persons, namely Abdul Kalam, Jahanuddin, Minarul Islam, and Abdul Ghani promised to sell the informant a plot of land measuring 25 acres at village Kodamtola, Gwalpara. Full stop. Accordingly, a sale deed was executed between the accused persons and the informant and an amount of rupees 2,70,000 was paid in 5 installments to the accused persons. It is alleged that in spite of the payment of the aforesaid amount, the possession of the land was not given to the informant, and therefore later on when he inquired about the matter, he came to know that the accused persons in fact were not the owners of the land proposed to be sold to the informant, and they are brokers. They are the brokers and misappropriated his amount. Full stop. In terms in view of the aforesaid FIR, Mafia PS case number 63/2026 under the aforementioned section was registered against the accused applicants, against the accused persons. Full stop. The learned counsel appearing for the accused applicant submits that he is one of the relatives of one of the accused persons and nowhere involved in the deal that has been made between the informant and the accused persons. Full stop. Full stop. He further submits that the entire dispute, if at all, is of civil nature. Therefore, the accused applicant should be granted PRS bail. MS S.H. Bora, the learned APP, on the other hand, opposes the prayer of bail application at this stage without perusing the case diary. Full stop. Taking into account the interfacts of the case and facts of the case, this court is of the considered opinion that the accused applicant should be granted PRS bail. Accordingly, it is directed that in the event of arrest of the accused applicant by the investigating authority in connection with Makia PS case number 63/2026, the accused applicant shall be released on pre-arrest bail on furnishing of bail bond of rupees 30,000 with a security of like nature to the satisfaction of the arresting authority subject to the following conditions. Accused applicant shall appear within 10 days, shall cooperate, then shall not tamper hamper. In terms of the aforesaid direction, the instant AV application is disposed of.
FIR is case 9 months. Here, my lord, the 3 persons, my lord, already arrested. Case 9, my lord, 1, 2, 3 is arrested. I am case number 4 in the FIR. What happened, my lord? The Informant lodged the affair that her husband was assaulted by the present
Heard
petitioner.
Mr. Anuddin, the learned counsel appearing for the accused applicant, also authorized for a learned APE for the state. Is an application under section 482 of BNSS 2023. Which we paying for granting 3 years bail to the accused applicant in connection with Divgara PS case number 44/2026. Call for the CD, let the matter be fixed on 27th August. 27 August.
I'm glad.
27 August.
Adam says.
My pleasure, Lordship. This is a 3 years bail application, Lordship. FR will find Lordship page number 11 is the operating portion, Lordship. And the petitioner is the registered owner of the vehicle, Lordship. And prior to this incident.
One second. Yes.
My lord, the petitioner is a registered owner of the vehicle, Lordship. Prior to incident, Lordship, the vehicle already been sold out to one, Lordship. Kindly come to page number 14, Lordship. Already sold out, Lordship. And this is the agreement, Lordship. And subsequently, Lordship, the petitioner is the not.
Wait. Where, when have you sold out?
Lordship, in the 17 February 2026, Lordship. Kindly come to operating person, page number 15. And Lordship, and subsequently.
Who is the owner?
Occurred is, Lordship.
Saburuddin.
On 21/6/2026. And in the month of June, Lordship. And the vehicle is already in the month of February. And page number 16, Lordship, para number 3 is.
1 second.
Lordship.
Let me read it. What is the consideration of the sale?
Lordship. And Lordship, the already.
And where have you notarized it?
It is from the Lordship.
What is the consideration for the sale?
Lordship. Lordship, and there is the some Lordship, para number 1.
You tell me what is the consideration of the sale?
Lordship.
You are selling a truck to somebody.
Lordship.
What is the amount you have received for selling it?
Lordship, there is the finance vehicle, Lordship.
Correct. Finance vehicle,
I
only
number-
only EMI payment you are selling a truck.
Lordship.
Only EMI payment. Is it
Lordship,
possible? Heard, Mr.
Condition, so I do not know.
Heard
Lordship,
Mr. F. Hawk, the learned counsel appearing for the accused applicant, also heard MS.SH Bora, learned APD for the state. This is an application under section 482 of BNSS 2023. Paying for prior's bail to the accused applicant in connection with Boko police station case number 178/2026 under section 61 in bracket 2 bracket small a stroke 316 bracket 3 BNS. Call for the CD. Let the matter be fixed on September 10th.
Little earlier, Lordship.
No, September 10th. Yeah, all these documents are all, made after the incident. So, somebody will sell a truck without getting any money, huh?
Exact, Lordship.
Huh?
I have.
You want to fool the courts,
Lordship.
huh? You all, want to fool the courts. Just leave your place.
7.
Published, Lordship.
And only diary may be possible under rejection.
Third NJ Dr. Dalani counsel appearing for the accused applicant. Also heard Mr. MS.SH Bora, learned APE for the state. This is an application under section 482 of BNS 2023. Paying for granting bail to the accused applicant in connection with London PS. Case number 25/2026, registered under section 108 of BNS of BNS. Call for the CD. Let the matter be fixed on Hmm? 9th. Okay, 9th.
I'm online.
Wait, please, Your Lordship. My lord, as per your lordship directions, my lord, I
Ah,
have filed my additional affidavit bringing the records regarding my rejection of bail prayer. So
hmm.
for the 438 is concerned, anticipatory bail, my lord. Your lordship may kindly, now it is a my lord, I'm behind the bar for 68 days
Hmm.
for an allegation and offense under section 316(5), that is a breach of trust, my lord. Your lord, your lordship will kindly see the reason for rejection of my bail, pre-arrest bail, my lord, that is at page, in my additional affidavit, I stated everything, my lord, and that is at page 39 onwards, my lord. And the allegation was this, that I, along with other person, being a sub post office, my lord, I have misappropriated the accounts holders' money, my lord, which were deposited and I have misappropriated an amount of 15 lakhs, my lord.
And you are behind the bars for how many days?
68 days. My lord, your lordship will kindly 68 days. And your lordship, that is all our documentary evidence. If your lordship kindly see, when I was a sub postmaster, my lord, page 15, my lord, I have
You are postmaster.
sub postmaster in Barbara, my lord.
So
While
it is regarding the savings, savings thing. We have granted bail to some people. Hmm? Hmm? You are not aware. Okay, I think we have granted.
some people are granted bail, my lord. Look, I don't have the orders with me. My lord, what has happened, that is at page 15, your lordship will find.
Now let us see the affair.
My lord, first, your lordship kindly see the page 15.
Hmm.
That is at page, my lord, you'll get to know that is at page 15. That is my information to the superintendent of police in 2023, my lord. That Noyanjoti Das, my lord, so and so, he was also assistant to me. He has done the misdeed, and accordingly, my lord, the department, I have given a chart where from this money has been my lord, taken from this person, my lord. Mohanaghat sub post office, my lord. These are the 17. These are the amounts from where this amount has been misappropriated.
Then what happened?
Then what happened, my lord? I was directed to deposit an amount of rupees 10 lakhs. my lord.
Why?
I was put under suspension, my lord.
No, why
That-
you have been implicated? You have filed a complaint saying that somebody else has done it.
My lord, that is why they said that we will recover it from Noyanjoti Das and thereafter we'll pay it back to you. So because of what, my lord, annexure to page 19, my lord,
No,
I have paid
the money was recovered from whom?
from me, my lord.
From you.
Not
Why?
my-
Why?
My lord, because what my instruction is this, that I was directed to pay, your suspension will be revoked if you pay this
I
amount.
mean, is it possible, Mr. Bora? Somebody will be suspended and somebody will be asked to pay some. I mean,
No, my lord.
is this a story to be
No, it
believed?
is between the department, what department has says, my lord, your lordship kindly see.
Okay, we'll call for the CD in this case. Okay, we'll call for the CD and give you a date. Heard Mr. P. Bora, the learned senior counsel, assisted by
K. Bhattacharya.
K. Bhattacharya, the learned counsel, appearing for the accused applicant. Also heard MS S.H. Bora, the learned APP for the state. It is an application under section 483 of BNSS 2023, praying for bail to the accused applicant in connection with Dibrugarh Police Station case number 40/2026 under section 316 in bracket 5 of BNS 2023. Call for the CD. Let the matter be fixed on 9th.
It will be-
Dibrugarh.
mandated period will be over. my
You
lord.
are 65 days, 68 days.
68
no?
days, my lord.
68 days. Then we'll call it on. No, before that.
Before that, it will be, otherwise it will be
27th of 27th.
my lord. My lord.
It's a 90-day offense or 27th will come. Please, sir.
Oblige. my lord.
Worship can be after some time. I am late by sir.
Hmm? Why? What happened? Who is appearing? Where is Mr. Kal? Labor court. If you have a matter in High Court and you go to Labor Court, you could have gone to the Labor Court. Okay, pass it over. Pass it over.
40.
MSJ Das somebody. So we'll pass it over for time being.
Lordship, the interim is there, Lordship. Interim is there.
Interim is there.
Lordship.
Yes, now what happened?
The Lordship, the interim is absolute, I face the trial, Lordship. Interim shall continue, Lordship.
CDS come, Bodo?
Scan copy,
Oh,
Lordship.
scan copy has come. Yes, it has come.
I appear before the IO, Lordship. Lordship, why it is also tough. Absolutely. Lordship, the informant and the accused person as the own brother, Lordship. The land is for Lordship. But FIR page 80.
When is the next date?
The Lordship, I don't know.
Then what do you know? What do you know?
The Lordship, the petitioner was not received.
Hmm?
Petitioner was not received the summons, Lordship.
How can the case there will be no date? Don't give this kind of submissions. Bodo, let him go and appear there. Hmm? So, that's what I'm asking. When is the next date? But from here also, I cannot find out the next date.
Within 15 days, Lordship, within 15 days, I applied
Huh?
for, within 15 days, Lordship, the interim shall.
15/7 was last date. 15/7. 15/7, then there is nothing out here. You should find out now when exactly. Okay, heard, Mr. What is your name?
Ahmed.
L. Ahmed,
N. Ahmed,
N.
N.
N for Nuruddin,
Noor Zaman.
Nul Zaman. Okay, N. Ahmed, the learned counsel appearing for the accused applicant also heard Mr. R.J. Burwa, learned APP for the state. Raised an application under section 482 of BNSS 2023, praying for granting PR's bail to the accused applicant in connection with Borpata PS case number 46/2026 in bracket GR case number 142/2026 under section 126 in bracket 2/115 bracket 2/118 bracket 2/109 bracket 1/351 bracket 3/3 bracket 5 of BNS 2023. A coordinate bench of this court by order dated 19/3/2026 has granted interim 3 years bail to the accused applicant and accused applicant full stop. In the meantime, the charge sheet has been filed. Charge sheet has been filed, no?
Fine.
Charge sheet has been filed in the instant case.
By the month of April itself.
Month of April.
That certain number may be mentioned. Case number 74 of the 2026, dated 24/2026.
Okay, so okay, then you write.
Well, I'm sorry, my lord.
Hmm.
My lord, in this case, my lord, I have some legal submission, my lord. Yes, not today or any other day, my lord.
No, I mean, see now, charge sheet has already been filed.
Yes,
I mean, now you are in interim.
yes.
So you go and appear.
But that's the point, my lord.
Hmm.
If a person is in interim, my lord,
Hmm.
and subsequently charge sheet is laid,
Hmm.
so what will be the status of my interim bail, my lord?
Your interim bill will be
Whether it will
extended
continue till end of the trial or till I appear before the court. my lord.
until you appear before the court.
On that point, my lord, if a lordship fixes a date, my lord, I want to satisfy your lordship. I will satisfy your lordship.
Because see, interim bail is totally on the discretion of the court.
Yeah, exactly. my lord.
Correct.
Yes,
Now you have been given interim pre-arrest bail.
Yes.
You were not given anything else.
yes.
So interim pre-arrest bail till consideration of the case diary, TCR and other things.
Mine.
Correct. So now while considering the TCR and other things, the court has a discretion to give you certain
My lord.
time. Now, since charge sheet has been filed, the court thinks that like you should go and like appear there because the trial should proceed.
Yes.
Trial should proceed. So that is the thing.
My lord, exactly on the same point, my lord. Recently, my lord, in a
Supreme Court. Supreme Court.
So yes, my lord,
Hmm.
that's why, my lord.
Okay, so, Mr. Borwa, he's saying that like, there is some other things.
Can it be any not today, my lord? Day after tomorrow or Friday, my lord.
Tomorrow,
Tomorrow.
you do it tomorrow.
Day after tomorrow.
Day after tomorrow is
Thursday.
There's a copy of the my lord judgment may be.
Din sab din tomorrow judgment. Judgment ka ulay lo no. Only
you
on
do
that
some
point.
research work, Mr. Borwa.
We make the research, my lord. They want it, my lord, ready-made.
Okay, on the prayer of Mr. N.J. Datta. No, what is the ratio?
My lord, here what happened, my lord?
Hmm.
Same thing, my lord. During the pendency of the case, my lord, charge sheet was laid.
Hmm.
And the court directed, the word is there, my lord, he was directed to surrender before the court. So in our case also, if your lordship directs to appear before the court, same thing, it amounts to surrender, my lord. And the case, I have to appear before the magistrate court, my lord.
Hmm.
And the sections which are leveled against here, my lord, one is, my lord, attempt to murder. That is triable by the session judge. So there is every possibility, my lord, that the committal court may reject.
No, I don't know, will hear you, but like thing is that this is only interim pre-arrest bail.
My lord,
So interim pre-arrest bail till the consideration of the, as I said,
my lord.
CD and other things, CD, charge sheet or whatever, I mean like other facts. Now the court has a discretion to, make it absolute or give some other orders.
Fine.
I don't know. Anyways, like if Supreme Court has dealt with the matter, we'll look into the matter. On the prayer of Mr. N.J. Datta, the learned counsel appearing for the accused applicant, let the matter be fixed on fixed day after tomorrow. Give the date.
It will be, my lord, 20, my lord. I'm obliged.
May I please, the matter will take it after some time, after some time. When your case will argument.
Hmm?
After some time,
Why?
okay, so this will argument. Actually, we will withdraw it.
That time, my lord, one matter.
Yes,
Okay,
Hitler
okay,
is also
okay.
dear, my lord.
Mhm.
In the same line, we will also withdraw it.
Hmm. You're withdrawing this?
My lord.
By Ambuta, that day I have already published.
That has been recorded by your lordship. That has been recorded by your lordship.
No, that's there. Hmm.
And Ambuta, my lord, case has been registered, my lord, in voluntary cases. And my lord, we was already on non-posted action. Yeah, that's it.
No, your only grievance was that like they have, I mean, your grievance was that they should have mentioned it before this, in the petition. But they have not done so, but like they have done it by way of video, by way of submitting the orders. That is the only thing.
We submitted the order, my lord, and.
You go for the cancellation, no? That is the better, that you go for that.
But, my lord, that will take already.
Here also you have not mentioned.
My lord,
This case also you have not mentioned.
here also, my lord, the order was placed before the, my lord, on the same day.
But the same
Same
this
day.
thing.
It was an item note 7.
Yeah, where is the order?
Yes. On the last order is here, an absolute order is also.
Will you allow this, Mr. Borwa? You take that thing.
They pass any order, then I am not.
No. I mean, no. See, I mean, there has to be. I mean, see, if there is an application filed by any accused, and if he wants to withdraw it, this court cannot stop it.
That is my submission, my lord.
We cannot stop it.
They are doing this matter, my lord, after getting the.
So that is whatever the interim bail they have. I mean, the bail they have got. You go for cancellation, saying that no, this has been taken by misplacing the things. I mean, misleading the court. You go for that. But other than that, there is no other remedy to it. We cannot stop. I mean,
But my lord, when my lord, the case that was available on 27/7, my lord. It was
so that is why I am saying
about this.
you bring out all those facts before the court and file a cancellation bail application. That this has been, all these facts were known to them. In spite of that, they have not disclosed to the court. That is the way you should do it. It's not. I mean, I cannot. Stop somebody from withdrawing a bail application or anticipatory bail application. On what ground I'll do it? It is his choice. If he says that, like, let me be arrested by police, I don't. I'll go.
Yes.
That is his choice, Mr. I mean,
That is my submission, my lord. He choose to withdraw the application, my lord, after getting the absolute bail. my lord.
correct. That's what I'm saying. Absolute bail. He got how? He has placed those. I mean, orders before this court.
So
Those orders were considered.
that is true.
I mean, and court was brought to the notice only because they have not pleaded here. You are saying that this thing, and case diary was there.
That is that, my lord.
So all these facts you bring before the court and file for a cancellation, then those will be considered. But in this petition, how can I consider all those things? I cannot consider all those things. And somebody is like wishes to withdraw an application. How can I stop somebody that no, you cannot withdraw this? How can I do it? You can bring all those facts in the other application wherein wherein bail has been granted. You can withdraw. We can ask for this. No, this case, like I'm allowing withdrawal of this case. I mean,
I humble some cases, my lord, since the case is available.
see, Mr. Burua, we have already allowed 2 applications on the same ground. Now, can I go in a different way? Do you ask the court to go in a different way, divergent way? Can I do it? On the similar grounds, I have allowed them to withdraw the cases, and this has been stated before this court that orders were placed before this court. Those were considered by the learned court, so learned coordinate bench. After that, bail was given. Now, if you are saying that they have misled the court, they have suppressed certain facts, then you have all the choice. You can go for a cancellation. You bring all those facts, details before the court. The court will consider that. But how can I stop somebody to withdraw a petition? I can't do that. That if you want to go against this order, you can go, Mr. Burwa. I'm not. We are not. But this one I'm allowing. Case diary is there. I'm not going to look into the case diary because the similar orders have been passed, and I'm not going to pass a different order on the same facts and circumstances and similar facts. So I will allow this to be withdrawn. And if you think that like there is some order which has been passed illegally, then you can always challenge this. This always option is always there. I will allow this. The same order will go for this. I will record your submission, Mr. Borua. I mean, those submissions I'll record.
Order of the.
No, I cannot, I cannot,
Only
I cannot, record whatever you submit. I mean, if you submit something nonsense, I cannot record it. Then I cannot record all your submissions. Whatever I found that like these are reasonable submissions and these are genuine submissions and which has some which are material for the facts of the case, then I have recorded all those. And I am not obliged to record all the submissions that you make.
Only one submission, my lord, that may be get.
Mhm.
On 27/7/2026, my lord.
You bring all this, I'm telling you, Mr. Borua, I'm telling you, you bring that fact in your cancellation petition. You bring that fact. You bring that fact, say that case diary was available in spite of knowing that case diary was available. No, for this thing, that is not relevant. In the cancellation, it will be relevant. In cancellation petition, you bring all those facts. But in this petition, this is simply they are withdrawing it. I cannot stop somebody from withdrawing a petition. And I cannot go into all those details, what are facts were. I mean, that CD was there available that time. And how will I consider this?
Because the judicial passed by the honorable court, my lord. It was available on that day.
Who is they?
On 27/7, my lord.
When?
My lord, before the coordinate bench of this honorable court, my lord, case diary was there, my lord.
The case diary was there. What, you were sleeping or what? Then why didn't you tell the coordinate bench that lordship, you cannot pass this order because CD is available?
Because they have to get done.
What they have done? What kind of argument Mr. Borua is doing? Yeah, it is not expected from you, Mr. Borua. You have. I mean, Borua. I mean, don't.
My submission, let me, my lord, submit, my lord. After
I have heard you. I have given you sufficient
my
time.
submission is very simple, my lord. On 27/7.
You are saying that on
Case diary was
27 case diary was available, but in spite of that case diary was not looked into.
No, my lord.
Then-
They took adjournment, my lord.
They took adjournment.
After that, my lord, they have obtained that order, my lord.
That order, correct. So what they have done, they have misled the court. So you can go for cancellation of the bail. You state all those things there. Now, why not doing that and like arguing all in this matter? That I cannot record here. You bring all those things. You make all those submissions when you file for the cancellation. But in this case, how can I record all these things? I have not granted bail. In that case, I am just allowing to withdraw the matter. When they have already get a bail, how can I stop them? You tell me. They have already got a bail in another case, so they are not pressing for these applications now. How can I stop that? You bring all those things in the in the bail application which has been granted. You go for cancellation. You bring all those things. Those things will be considered, but not in this case. You are not understanding the things, Boro. You try to be reasonable. Yes, next case.
Anticipatory bail application, Lordship, I am already on interim. Perhaps the CD has not been received.
CD not received. You go and appear.
Some protection may be given till I appear. Lordship.
He's already on interim.
Yeah. So you go and appear there. Heard Mr. The learned counsel appearing for the accused applicant. Also heard Mr. R.J. Borua, the learned APP for the state. This is an application under section 4 ACP of BNSS 2023, paying for PRS bail to the accused applicant in connection with Davoka PS case number 44/2026 under section 69/74 of the BNS 2023. A coordinate bench of this court, by order dated 27/5/2026, has granted interim PRS bail to the accused applicant. Full stop. The learned counsel appearing for the accused applicant submits that in terms of the aforesaid direction, the accused applicant has already appeared before the IO and his statement has been recorded. The learned APP, Mr. R.J. Borua, learned APP submits the charge sheet in the instant case has already been submitted by charge sheet number
Party number, my lord, 44 of 2026.
26.
11/6/2020.
Okay, 44. Case number is also 44.
Yes, sir.
Check.
Party number is also.
Sure.
That has been my detailed manner.
Okay. Okay, so and so. In view of the aforesaid submission, the learning council appearing for the case applicant submits that that liberty should be granted to him to appear before the jurisdictional court. In view of the aforesaid, the instant AV application is anticipated to disposed of with liberty to the accused applicant to appear. Accused applicant to approach the jurisdictional court if so advised.
21.
Well, the petitioner is on interim, my lord. He appeared before the IO, my lord. Initially, case was filed under anticipation, my lord. One FIR was lodged, and subsequently, my lord, it is informed that the FIR has been registered, and so CD was called for.
CD has come.
26/6, if your lordship compare that order
Hmm.
of 26/6. And assurances were given from the side of the petitioner that it will be, this payment will be made in 3 installments within 3 months. Accordingly, the next date was fixed immediately after 1 month, that is on 27/7. This said submission.
Yeah, what happened to this?
My lord, till that, my lord, he could not pay anything, my lord.
Why?
My lord, he
Then
lost.
I will cancel your interim bill.
Lord, he lost his job, but that is why, Lord, as your lordship, my lord, lordship will see the case diary and lordship will call the order.
Then case there is there anything? But he has given assurance, on his assurance, the interim bill was granted.
Second order of
So we'll cancel it.
7/7, that is very much reflected. Certain bogus allegations has been brought against me in the petition itself. Not a single penny has been invested in the share market.
He has used this for household expenses and this thing.
My lord,
Very
another
unfortunate.
friend knows, my lord, the payment has, admittedly, money was taken, my lord. For
Second, and like, I mean, see, had it been things that he has invested the money, he has suffered some loss. It is not like that. He has taken it to cheat somebody.
That intention was very much there from the very beginning.
We'll cancel this. Mr. Kaulita, there is no other way.
Otherwise, my lord, the alternative remedy is there. He can avail the civil remedy.
Civil remedy is, I mean, that's what I'm saying, that the intention to cheat is already there.
Yes.
It's not that he has, had it been something like that he had taken the money and he was investing in some share market or something, then he suffered loss, and in his statement, nothing as such has come. He has stated that he has taken the money, but he wanted to invest, but he did not invest. Then he was household expenses increased and he spent the money. I mean, this kind of a thing you can do. Somebody has in good faith pays you amount, and like you do this kind of thing. Right, heard Mr. M.K. Kolita, the learned counsel appearing for the accused applicant. Also heard M.S.S.H. Bora, learned APT for the state, as well as Mr. H. Sharma, H. Sharma. H. Sharma in person for the informant. In person for the informant. This is an application under section 482 of BNSS 2023, praying for granting PRS bail to the accused applicant. FR was subsequently lodged
Yes, sir.
in connection with Panbazar PS case number 155, Paltan Bazar PS case number 155/2026 under section 318 in bracket 4 of BNS 2023. FI was lodged on 6/6. And then you next you write, next paragraph you write, CD in the instant case has been called for and the same is received. And the same is received and perused. Full stop. And FI was lodged on 6/6/2026 by the informant alleging internally that the accused before the Paltan police station, no? Paltan police station alleging internally that the accused applicant induced the informant for investing money with him, which he promised to invest in share market. With such induced, it is alleged that since with such inducement, the informant started paying rupees 5,000 from the month of June 2022 till June 2025. He paid till when? June 2025. You paid 5,000 rupees per month till which date? Which month?
Till Lordship, May 2025.
Till May 2025. 225 rupees 5,000 per month, till May 2025. And accordingly, the total amount paid by the informant to the accused applicant for investment came to rupees 2,56,121. However, it is alleged that when the informant asked him about the returns, the accused applicant failed to give any reasonable right, any convincing reply. When it is alleged that when the informant asked for the documents regarding investment in the share market, the accused applicant could not provide any details of the same. Full stop. Faced with the aforesaid situation, the informant has filed the FIR Full stop. On receipt of the FIR, police registered Paltan Bazar PS case number 155/2026 under, you write that section under 318 in bracket 4 of BNS. Then you write on apprehension of arrest, the accused applicant had approached this court by filing the instant anticipatory bail application, and on 26/6/2026, a coordinate bench of this court, after hearing the parties and on the assurance given by the accused applicant, that he is willing to return the entire amount of rupees 1,80,000. Why this amount 1,80,000?
Lordship, though he has promised by this agreement to make the payment of 2,56,000, but I paid 1,80,000. I only want that. That is why I said it like that. I don't need the extra amount.
Okay. Then that statement of 2 lakh in the FIR, FIR you have written that the agreement as per the agreement. Okay, then you write, then they make it 180, huh? The 180 and then you write one line there, that by an agreement, the accused applicant, by an agreement executed between the informant and the accused applicant promised him to return 2 lakh, that amount, huh? 2 lakh, so
Because on that day, query was made from this honorable court that whether I need, so I said then no, I don't want that extra money.
he hasn't given it, spent in the, I mean, he hasn't done any this thing. And where will you get that amount?
He has just
Okay,
put enough all my money in Lordship for his own benefit.
okay, then you write, return the entire amount of 1 lakh to them within 3 months. Within 3 months, full stop. The learned counsel appearing for the accused applicant submits that in terms of the aforesaid direction, aforesaid or the interim order dated 26/6/2026, the accused applicant has already appeared before the IO, and his statements have also been recorded. It is seen that on 27/7/2026, the interim order dated 26/6/2026 was extended for a period of 15 days. 15 days. On 15 days on the assurance again that the entire amount of rupees 1,80,000 shall be paid within a period of 3 months. Okay, last line, what was it? On 15 days, however, no payment. Extended for another 15 days, but however, no payment has been made till date. Till date. Yes, till date. The learned counsel for the accused applicant submits that due to certain financial difficulties, he could not arrange the money and so he could not pay the same. Taking into account the proceedings, taking into account the entire facts of the case, and that the accused applicant could not fulfill his promise, his assurance of paying back the rupees 1,80,000 within the stipulated period. Within the stipulated period, this court is to consider view that the interim PRS bail granted to the accused applicant should be cancelled. Accordingly, the instant AV application is disposed of by cancelling the interim bail or interim PRS bail order dated 26/6/2026. You're cancelling this, Mr. Khalid. You have cancelled the bill in 20.
22 and 23.
Lordship, he eventually appeared before the investigating agent. The CD not received today also.
CD not received.
We are in train.
Okay. Mr. So-and-so is present
Yes.
and Mr. So-and-so. CD not received. Interim order so passed earlier shall continue till the next date. With them at fixed on
40 September.
14 September.
Lordship.
23. 23 also entering there.
Hmm?
23 also entering there.
Sorry?
Item 23. I.
23 also? Same.
Entering there.
Okay. Then write his name and present. CD not received, interim.
Lordship.
Next day to them.
24.
May please. The interim order dated 24/6. What is the petitioner APR? Because there was confirmed.
Hmm?
Yes, there
Is that is come?
24.
CD not received, later matter will be listed on. When? 14th, an interim, so order or continue.
25.
Interim bail was considered in my favor and I appeared before the IO and recorded my statement.
CD not received. Okay, CD not received, interim order to continue till the next date of listing. Later matter will be listed on 14th. 16th September.
26.
It is about 26 and 27 out of the same empire.
Hmm?
Item number 26 and 27, the same affair. I'm on interim, Your Lordship.
Oh, it is-
Petitioners have appeared.
So we can- Okay, January is- তুমি কল ফোন সাম সাইলাম অর্ডার আপনি ঠিক করে দিলাম হ্যাঁ এটা তো একটা ভিডিও সিডি কোন হলে সিডি রাখতে দিবা পিছে দিন দিবে Okay, rights updated CD is not received. Interim order to continue till the next date. Let me the matter be listed on 17th.
Both the
17th.
cases, I am on interim, Your Lordship.
Huh?
I am on interim in both the cases.
Okay. 17th. Both the cases, huh? Both the
28.
cases.
May please, Your Lordship. Here the petitioner is on interim lordship. As per my instruction, he appeared before the investigating officer. He is a practicing lawyer lordship and during his initial days lordship, he fell in love with a girl and she lordship wanted to get married, but because of financial constraint lordship, he said that he needs some time. And because of that, some dispute arose and this present affair was lost. He is willing and ready to marry. He never refused to marry lordship. In fact, I have stated in my petition also that he is ready and willing to marry.
Yes.
May I try to say the victim that will.
In fact, victim is also pursuing her law lordship and in the FIR also your lordship will find all those provisions are clearly mentioned. So lordship, before that.
Yes. You are paying for money. Hmm? Legal aid counsel. Why, you- I mean, why you are paying? Okay, what do you have to say? Hmm. Okay, as a Mr. Ahmed, it will be difficult, I mean to extend this.
Lordship may kindly consider one aspect, Lordship, that they were in a love relation, that is not disputed, Lordship. And she wanted to get married, that is also not disputed. And Lordship, only thing is that allegation is that I am not willing to marry, Lordship. In fact, I have stated clearly in my petition also, and that is reflected in
But this says something, I mean, CD says something else.
regarding.
Yeah, I mean, CD says totally different thing.
No, some dispute was there. I am not saying that
No,
part. Lordship, young lawyer, Lordship, because of financial.
No, I mean, you are being an advocate, you've exploited a young girl.
No, that
And there is no
exploitation
excuse about this. There cannot be any excuse about
or in
this.
that case, Lordship may grant sometime he will try to reconcile the
No,
issue, Lordship, between the parties because
You,
ultimately,
I mean, you have all the options, but I cannot extend this. Hmm?
so ultimately she is not coming up now because he has Lordship clearly said that he is ready and willing.
I mean, Ahmed, the CD has different story
If
altogether.
anything is there, he will face trial. Young Lordship, if at this stage he is
Let him
taking-
let him face trial. Let him face trial, but not with the help of an anticipatory bail.
Okay,
Heard
Lordship,
Mr.
can you
Ahmed,
take
the learned
one
counsel.
aspect, Lordship, just
Heard Mr.
short submission, Lordship.
Heard Mr. What?
Page 16, Lordship, may kindly see page 16.
16.
16 of the part of the FI. In fact, she has given all the definitions of sections. So she know how to draft a Lordship
She knows.
FIR.
Yes,
and
she's a
that
law
is also-
student, she knows.
Yes,
Maybe
is
she's a very bright law student.
yes.
She's a bright law student, not like others who while studying law, they do not know anything. But she's a bright student, she knows about this. Is this a crime?
No, there was some discord. I am
No,
saying
is
that-
this a crime? Is why you are submitting on that point?
No,
Is
because-
this a crime to know something?
No, that is not the crime, Lord.
Then-
Because she knows everything. There might be some
She knows
statements.
everything. See, I mean, it's now 17 years old girl also may know lot many things. AI is there, Google is there. You are aware of this.
So the
Everything is known to
clever
everyone.
drafting and
But-
the clever statement that will also be
But
obviously there. So
there are sufficient materials against
on
you.
some time may be granted, Lordship, he will try.
He is not willing to.
Let him
Uh,
maybe give one opportunity, Lordship. By next week, he will try to settle this because ultimately the life of both girls and boys are there, Lordship.
Have you spoken to her? No. She's present. I can't help.
Let them talk between them, Lordship. I cannot talk to her, Lordship, at least.
No, they are not willing to. The girl is, he's saying the girl is present and she's not willing to.
No, ultimately there was love affair, Lordship. There was relationship of
No,
2
no.
years. Relation of 2 years was there. So at least they will give
See,
you one
that
chance.
material suggests that you had done this thing to other girls also. Now don't, I mean, force me to open my mouth. You have done it to the other girls also earlier. Same thing. You are habitual in doing this kind of things. After ditching this girl, you went to Sipsagar and wanted to marry somebody else. Yeah, fix the marriage.
As per my instruction, no marriage.
This is there. No marriage happened, but this is there in the CD. You're forcing me to divulge the things.
So let him clarify those
No.
aspects with the guard.
Why should I wait for the clarification? This is there in the CD. I'll
Because
go
no,
with
there-
this.
As per my instruction, there was.
Let your instruction be, you
I
take
have
your
stated
instructions
the
and
petition also.
and be happy with that. Heard Mr. A. Ahmed, the learned counsel appearing for the accused applicant. Also heard Mr. R.J. Burwa, learned APP for the state, as well as Mr. U. Chaudhary, the learned counsel, learned legal aid counsel appearing for the informant. Full stop. Now, this is an application under section 482 of BNSS 2023. Praying for granting pre-arrest bail to the accused applicant in connection with Jalukbari PS case number 264/2026 under section 117(2)/351(3)/69/69/79/89 of BNS 2023. An FIR was lodged on 13/7/2026 by the informant. The informant before the Jalukbari police outpost, alleging inter alia that the accused applicant, who is an advocate by profession, by way of false marriage, exploited the informant sexually. And when she became pregnant with his child, he forced her to terminate the pregnancy. Full stop. It is also alleged that that after they started staying together and having physical relationship, for many days, full stop. For many days, the accused applicant started behaving differently and started abusing her after consuming alcohol. When she protested about those behaviors, the accused applicant started torturing her. Full stop. It is also alleged that in spite of having the relationship with the accused, with the informant, the accused applicant was maintaining his relationship with his ex-girlfriend, whom also he ditched after promising marriage. It is also alleged that in spite of the living relationship with the informant, the accused applicant went to his native place and fixed and fixed 1 second, 1 minute. Okay, don't write that. Last line you cut. In view of the aforesaid, FIR, the police registered Jalukbari police station case number 264/2026 under the aforementioned sections. Then you write a coordinate bench of this court right order dated 23/7/2026 granted interim pre-arrest bail to the accused applicant and directed him to appear before the investigating officer within a period of 10 days from that order. First of, the learned counsel appearing for the accused applicant submits that accused applicant is willing to marry is willing to marry marry the informant, and the whatever happened is not intentional, and there was no torture by him on the informant. He submits that there was a love relationship between the accused applicant and the informant, and during such relationship, some tussles, some minor tussles happened, but there was no, there was no harm caused to the informant by the accused applicant. Full stop. He submits that he is still willing to reconcile with her, He further submits that in terms of the direction dated 23/7/2026, the accused applicant has already appeared before the investigating officer, and his statements has been recorded. In view of the aforesaid, the learned counsel praise for the interim order to be made absolute. On the other hand, the learned APP, Mr. R.J. Borua, submits that there is some incriminating material against the accused applicant of his involvement and harassment of the accused of the informant by the accused applicant on the promise of marriage. Also, Mr. U. Chaudhary, the learned legal aid counsel, appearing for the informant, submits that the informant has been harassed on the false promise of marriage, and she had to undergo an abortion because of such a relationship with the accused applicant. He submits that the informant is not willing for any kind of reconciliation with the accused applicant at this stage. Full stop. Next one. The case diary in the incident case has been produced and the same is perused. On consideration of the materials available in the case diary and the submissions made by the counsel appearing to the respective parties, this court is not inclined to grant absolute PRS bail to the accused applicant. Accordingly, the instant AV application is rejected, and interim order passed on 23/7/2026 is cancelled.
Obliged.
CD to be returned.
Obliged was for accommodation, my lord. He was in other court, man.
Not an issue.
But this case, my lord, regular bill last time it came, worship was pleased to on a call for the city in a short time, my lord. Today is 42 days, man. 42 days. And if you exclude section 148, 60 days is the statutory period, man. And 148 does not come, my lord. 142, Lord. Allegation is not by the one NOC in regard to the sale of the land was obtained by one Amjad Hussain. It was found to be, my lord, suspicious. On inquiry, Amjad Hussain said that the present petitioner and another, they have given it. This is the case, man. FIR is, my lord, page 13. You want to treat it? E18 cheating, 336 forgery, my lord. And 148 fantasy also.
Yes, Mr. Borua.
But the chief second, he has given second putting the field. He has looked at the word one aforesaid. One authorized and you see it. He looked at then after saying the annual paper, it was handed over the 18 by one. Then after verification, they have to notice this was a state. Then whether the fee, that is to be development authority also one, they have also verified that they think it is not issue from all of it. It is a station. No, but as far as situation like concerned, it is a matter of petition writer. He is a petition writer. I don't say it was early in the, he's a petition writer and he wrote with one of the main issues. He said, I wrote with Mr. Faru and he used to buy the office of this thing. Regarding social partner, where done and what manner of this is other investigation, because they are taken yes to apprehension. The very village. It's like the case of
Yes.
Farooq Sheikh is accused number one, man. And actually, in fact, my only question about the further custody might also, and this section is not coming.
There are, I mean, this kind of offenses take some time.
It is matter only
Yeah,
because
it-
Farooq
it-
Sheikh matter. Amjad
It takes some time.
co-accused statement, man.
And this kind of record is,
No, it may be there, but I am not saying so, my lord, because, but 42 days already done, it is not a ABM, my lord. 42 days already he has undergone, my lord. And there is no direct allegation against Farooq Sheikh, my lord. And I am a petitioner writer, I write my something, I am under him, my lord. It is not my job, my lord. And it is stated by one Amjad Hussain. Other accused, my lord, the person in whose name, my lord, this NOC was given. He has, my lord, implicated the present petition.
Amjad Hussain is the victim, right?
Not
Victim means like, I mean, not victim.
He is not victim, but he is the person, he is the beneficiary, my lord. He is
He's
the
a
beneficiary.
beneficiary. And Amjad Hussain disclosed that Farooq Sheikh has given. Right?
Yes.
Farooq Sheikh and the accused applicant.
No, Farooq Sheikh has given, and so far I am concerned, what I have understood from my learned friend, my lord, so I am the petition writer, I am under him, my lord, that is. If at all somebody is there, Farooq Sheikh may be there, not the present petitioner. Even then, my lord, it is not AB, my lord. I think your lordship, further custody and everything is there, my lord. NOC already they have inquired into that about the NOC. my lord. Investigation almost, my lord, completed as per investment. And he has no relation to Amjad, he does not know Amjad Hussain. We have made a statement also, my lord.
Amjad Hussain, he has been arrested? No.
that's the victim.
No, victim, he paid some money, no?
He paid some money.
He paid money
beneficiary.
he paid money 57,000.
He paid money, 56,500.
Correct, 57,000 to
Farooq.
Farooq to get this fake certificate. So he is also involved, that means.
Yes, my lord, in the case of this statement, my lord, Amjad.
Yeah, let me see. But as per the FIR, it seems that Amjad Hussain has got this fake certificate. It is not that he is not aware. Why? Otherwise, why he will pay 57,000?
So he paid money. To register the mother, then he is this same in his father.
No, to get NOC, he has paid this much of money.
the process of verification, my lord, he submitted those NOC. But it was obtained, my lord, through my lord, is Farooq second, my lord, alleged.
Already 42 days.
I'm only on that, my lord.
Waiting to the state not happy.
Heard Mr. H.R. Chaudhary, the learned senior counsel, assisted by so and so. Also heard Mr. R.J. Boro, learned APE for the state. There is an application under section 483 of BNSS 2023. Paying for granting regular bail to the accused applicant in connection with degree PS case number 252/2026 in bracket corresponding GR number 783/2026 in bracket under section 61 bracket 2/318 bracket 2/336 bracket 3/148/3 bracket 5 of BNS. An FI was lodged on 7/7/2026 by by one Raju Roy, building inspector before the officer in charge, Dhubri Police Station, alleging inter alia that the informant is a building inspector in the office of the chairman, Dhubri Gauripur Development Authority. It is alleged, then he write, it is alleged that on 7/7/2026 at about 11 p.m. during scrutiny of office records, the NOC for sale of land submitted by one Amjad Hussain was found suspicious. The signature purportedly of chairman and the NOC's format displayed anomalies, and memo number did not match with their office register. It is alleged that on calling Amjad Hussain to the office, he stated that the accused number 1 and accused number 2 had supplied the forged NOC instead of the original after accepting rupees 57,500 from him, from the informant. It was alleged that both the accused persons told him that the NOC was original and genuine. It is alleged that the accused persons have framed false documents and forged signatures for wrongful gain from affecting government records and revenue. It is alleged that similar illegal activities appear to have been carried out by the same nexus for the past 6 to 7 months, and the criminal nexus cheated a mammoth forgery and also cheated the gullible people. It is alleged that the offenses strike at the national interest and economy of the state, which is against the nation. Full stop. On receipt of the FIR, police registered the VPS case number 252/2026 under the aforementioned sections. The learned senior counsel appearing for the accused applicant submits that the accused applicant is in fact not involved in the alleged offense as narrated in the FIR. He submits that he is a person who works. He's a person who works with the other accused person, namely Farooq Sheikh, and he has not committed any offense. Full stop. He further submits that the accused applicant is behind the bars for last 42 days, and the section 148 of BNS, which has been registered against him is not applicable in the instant case. He submits that taking into account the opposite facts, the accused applicant should be granted bail at this stage. On the other hand, Mr. Arzoburu Angalani PPP submits that the main accused, Mr. PROCEED, is yet to be apprehended and the investigation is still on. He submits that there are sufficient incriminating materials against the accused applicant, of his involvement in the instant case. Then CD in the instant case has been produced and the same is produced. Then we are taking into account the entire facts of the case and having found sufficient incriminating materials against the accused applicant, this court is not inclined to grant any bail to the accused applicant in this case. The bail application is rejected.
CGM do
The bail is rejected, Mr. Chaudhary.
rejectable.
May I please, Your Lordship? My Lord, it's a pre-arrest bail application. I am on interim, my Lord. Basically, my Lord, allegation of adultery, my Lord, and 498A, but there's no cruelty on that such, only on adultery, and she has filed this FIR after I filed a petition for guardianship of my child, my Lord. I have already appeared, my Lord. Probably custodial detention is no longer necessary, my Lord.
Mr. Boro, CDS come?
There is the iron of money. So in pure paper money, this man is the client is already on interim protection. So that's the absolute case that we be performed. This is the other truth of the
FIR itself is only for the purpose of that allegation of adultery, and adultery does not constitute a cruelty, my Lord.
investigation is pending, madam.
Adultery doesn't constitute cruelty.
Yes, ma'am.
How?
There is a judgment of the Supreme Court today. Probably last order has also reflected that, madam. This is the orders.
Order to reflect or answer.
Nothing.
In time, madam.
I'll just read out the statement. That is nothing to be hidden. See, at this stage investigation, the allegations relating to coercion for obtaining signatures on blank papers, installation of hidden camera, blackmail, and other connected allegations have not yet been corroborated by any independent oral or documentary evidence.
Till now.
Till now, nothing could be done. The hidden camera could not be found in the place. That was the allegation.
And that too in a court premises, madam.
Yes, where is the case?
2009 6 SCC, my Lord, 757, madam. The last order has also reflected that, madam.
498 is what? 498 is
7 years, madam, 3 years.
no, 498.
Here it's 85. Now it is 85. BNS, my Lord, originally 498. The 3 years punishment, but non-bailable one.
But that can be a cruelty for dissolution of the marriage,
Yes,
but not
not for 490.
498. Heard Mr. A.M. Bora, the learned counsel, assisted by Mr. B.A. Chaudhary, learned senior counsel, and assisted by Mr. B.A. Chaudhary, learned counsel for the accused applicant, also heard Mr. R.J. Bora, learned APP for the state. This is an application under section 483 or 482 of BNS 2023, paying for granting bail to the accused applicant in connection with Happytown PS case number 132/2026 under sections 85/82/77/352 in bracket 2 /3 bracket 5 BNS 2024. This court by the coordinate bench of this court by order rated 23/7/2026 has granted interim pre-arrest bail to the accused applicant with the direction to appear before the IO. Every fortnight you are supposed to appear, and you have been appearing.
Interim order, my lord.
So
As and
interim.
when I'll appear, my lord. As and when required, I'll appear. This kind of cases, marital dispute, my lord.
And he has also, my lord, went for the second time, my lord. That is, my lord, clearly reflected from his own statement before the IO. After obtaining the, my lord, clearance.
Directed, he appear before the IO every fortnight till the completion of the investigation. The learned senior counsel submits the with direction in the order dated 23/7/2026 that the accused applicant has been regularly appearing before the IO. Have been regularly appearing before the IO. Please stop the learned APP, Mr. Borua. He's appearing now, Mr. Borua. There is no. Mr. Borua has also confirmed that the accused applicant has already appeared before the IO, and his statement has also been recorded. Full stop. Full stop. The learned senior counsel submits that since the accused applicant is cooperating with the investigation and willing to do so, custodial detention of the accused applicant should not be required, may not be required, and therefore the interim pre-arrest bail granted to the accused applicant should be made absolute. Full stop. CD in the instant case has been produced before this court, and the same is produced. Mr. Borua on the other Mr. Borua on the other hand opposes the prayer for bail, prayer for pre-arrest bail by submitting that the investigation is still going on and still going on and therefore at this stage the accused applicant should not be granted pre-arrest bail. Please stop. after taking into account the submissions made by the council opinion for the respective parties and on perusal of the materials available in the case, this court is of the considered opinion that the interim PRS bail granted to the accused applicant on 23/7/2026 should be made absolute. Accordingly, the interim PRS bail granted to the accused applicant is made absolute. Made absolute. Any conditions you want, something?
Yes.
Yeah. See, there was a condition of fortnight appearance. Are you appearing fortnight? Every fortnight?
Okay, Rajan, when these kind of cases, what is
No,
the
no, I don't know, but there is an order here.
That is an interim order, my lord. That law,
Hmm.
final order, lordship can decide.
My humble service, my lord, only after my lord getting the my lord, absolute bail, my lord. He will never, my lord, become the my lord victim, my lord. And secondly, my lord, the minor son of the victim and the.
That we have filed it.
Person has already taken away the minor son. Family. So this is also under.
That is pending, my lord.
Those
That-
things we are not doing, but like will say that like, I mean,
That is the pending, that is the case, my lord.
Hmm.
We have filed a guardianship case. And the taking away the recent Supreme Court judgment, taking the son, it does not constitute an offense of, my lord.
subject to the
Kidnapping.
condition that the accused applicant shall cooperate with the investigation and make himself.
And marrying again, my lord, I think my friend should not be jealous of me, my lord.
Not at all.
Uh,
Here, my lord, there is a my lord interim order, my lord, directing with the APR, my lord.
Now we'll give some condition.
It is
We'll-
the pedagogy of the investigating officer.
Yeah, we'll.
If you want, my lord, this-
Yes, that is what I'm saying, as and when
No,
required.
we are see, Burwa, we are saying that like he will, I mean, whenever he is required, he will appear. He'll cooperate with the investigation, correct? And he will not get in touch with this. He will not try to get in touch with this lady, the informant.
then, my lord, all respect, my lord. Then the APR, my lord, partial to the interim protection, my lord, and whenever IO, my lord, directed to APR.
That is what I'm saying.
Yes.
That is what I'm saying. Fully cooperate with the investigation and appear before the investigating officer as in when he is required by the IO. It is also made clear that the accused applicant shall not try to get in touch with the informant in the instant case. In terms of the aforesaid directions, the instant AV application is. See, first is like he will appear whenever he fall. He'll cooperate with the investigation. Secondly, he will not try to get in touch with the informant. Influence.
Obliged, highly obliged.
Mr. Chaudhary, you can take this.
Please, your lordship. 482 application, my lord.
CD has come. Hmm? Last time also it was awaited.
My lord, there is a 55 days delay in the FIR, my lord. I want to produce two judgment, my lord. I am not saying that the delay is fatal, but my lord, there should be some explanation in the FIR, my lord. Otherwise, my lord, then adverse inference can be drawn against the prosecution. On that ground, my lord, I am not pressing for, my lord, interim, my lord. Now, does that mean that there is a 55 days delay in the FIR? In the meantime, they will blackmail us for money based on an unfortunate death of a deceased, my lord.
You come to the FIR.
My lord, FIR, my lord.
All are there.
My lord, page number 18, my lord. Page number 18.
Yes.
May I read, my lord?
Not required. I'll just read it.
My lord.
Yeah, how many days delay?
482 application.
No, how
Delay
many
is
days?
55 days, my lord. 55 days after the death.
Hmm.
But the father claimed that he knew before that there was cruelty. He did not report, my lord. But even after 55 days of death, in the meantime, they were blackmailing us. That you give us money or we will file an FIR accusing you of cruelty, which was not there at first place, my lord.
Is there any evidence of that?
My lord, with regard to that evidence, my lord, after she consumed poison on 16, my lord, he was taken to hospital till 28, my lord. Full medical treatment was given. I am not saying that that is a, but it shows how concerned we are, my lord. There are some domestic problems. Unfortunately, the deceased she was insisting that the accused should go and live with the.
When she consumed the poison?
My lord, may I say this, my lord?
No, when she consumed the poison, I am asking you.
16.
16/4. And when she was taken to the hospital?
The same day.
Hmm?
Same day, my lord.
26
She was taken to the hospital on 26/4/2026.
There were several, not just Dispur hospital, but initially she was.
Wait. I am just asking you. You show me from your records that she was taken to the hospital on the same day.
But initially she was taken to the government hospital. We did
No,
not.
show me where he has been taken, and where is your statement that she has been taken on the same?
We have
Where is your statement?
The statement is, my lord.
Statement and substantiate with your statement.
Para 8, no? Para 8, my lord. Page number 6. Para 8, my lord, page number 6.
Where?
May I read the true fact of the case from here, where we have narrated the incident, made arrangement to visit the hospital, look after the injured brother. This is about the brother. And then next, this last para. Treatment and first shifted to her to Tulsibil Primary Center. From there, she was referred to Gosaibil.
When? She was shifted when?
This is on the immediately.
When? Where have you stated so?
This is page number 6, my lord. Page number 6.
Where are you reading?
Page number 6, last para. May I read, Your Honor?
One second. Last para.
Last para. It is specific case of the accused that out of anger, frustration, the accused number 1 refusal to comply with an insistence. The deceased consumed grass-killing poison. Soon thereafter, when she started vomiting, the accused person immediately arranged for her medical treatment.
CD is not there, no? What is there in the CD?
The statement of the patient as well as the independent witnesses. And the medical reports was found to be pregnant with reference. And this is pregnant.
She was pregnant. We are all bereaved, my lord.
Both physical and mental torture by this process. That is also there.
One allegation. My lord, just one point, the fact that she was immediately taken to the hospital is also mentioned in the FIR. The informant says that she was given medical treatment. We have annexed only Dispur hospital's prescription, but immediately she was,
Immediately taken to nearest.
the FIR itself says.
Are there any supporting documents in the next evidence?
When the family members were intimated?
The family members immediately was intimated.
Where?
Immediately. We have not mentioned that.
How you are saying, but in the FIR said that it was concealed from them.
But in FIR, they are saying lot of
It was
things. In
concealed.
the FIR,
Yeah, we'll go by the FIR only at this stage.
my lord.
Because there are, at this stage, we can go by the FIR as well as the CD, nothing else.
Not with
No,
respectfully.
we are not.
Respectfully, I want to submit. Even going by the FIR, there is a 55 days delay.
55 days.
Even going by the FIR, there is no
maybe-
explanation, my lord.
Maybe delay. Maybe that
There is no
prosecution,
explanation, my lord.
that prosecution will prove in the trial. I am not convinced. There are sufficient materials against you. I am not giving you bail. Okay. There are
But at least
sufficient,
for 2 and 3,
sufficient materials.
elderly parents, my lord.
Sufficient materials are against you, which implicates, which points finger towards your involvement, your family's involvement. So if there is something, I mean, to be proved against those allegations, that you have to do it before the trial. But at this stage, I'm not convinced.
May I rely on true judgment, my lord?
The judgment, you can place it before the trial court. What I can do? Prosecution will prove they are not here.
My lord, at least for 2 and 3, their only allegation is that ill advice. That is the only allegation against them.
This is a concerted effort. I mean, see, all these kind of thing, that's Mr. Aman.
My lord.
All these cases, these are concerted thing. All family members see, like, nobody, it is not hidden fact. Correct. It's not hidden fact. I mean, now it's not that like anybody, a husband has put the poison. No, poison was taken by her only, but it's a concerted kind of thing. So now at this stage, we cannot decide whether if she was involved, he was involved.
One last submission, my lord.
No, yes.
She was insisting that the accused petitioner number 1, which is the husband, lives at the matrimonial home. And on 13th, the younger brother made with an accident. And she was insisting that the elder brother, which is the accused petitioner number 1, should not incur any expenses. That was the trigger point. And that's why she consumed poison.
But
and my lord, she was pregnant. The child is of accused petitioner number 1, my lord.
That is the most important and material fact. Since she was pregnant. And do you think like any mother can commit suicide?
And like,
wait, when somebody, and she's like having a child inside?
It is very unfortunate, tragic, my lord, but we are all bereaved.
No, we don't believe
We are all bereaved, my
we
lord.
don't. You may be in bereavement.
They were blackmailing
You may be in bereavement, Mr. Adud. You may be in bereavement. That doesn't matter to us.
At least for 2 and 3
matter to us, like no, nobody will be granted bail. Heard Mr. A.W. Aman, the learned counsel appearing for the accused applicants, also heard Mr. S.H. Bora, learned APP for the state. There is an application under section 482 of BNSS 2023 praying for anticipatory bail to the accused applicants in connection with Visayagaon PS case number 131/2026 under section 85/108/351 in bracket 2/3 bracket 5 of BNS 2023. An FIR was lodged by the informant, namely Samsul Haq, on 22/6/2026 before the officer in charge Visayagaon police station, alleging inter alia that his daughter was socially married to accused number 1 on 21/6/2025. 21/6/2025. Semicolon, and that soon after the marriage, the accused number 1, the instigation of the accused number 2 and 3, started subjecting the deceased to physical and mental cruelty. Semicolon, that while the deceased was 5 months pregnant, she visited her parental house on 9/4/2026 for casting her vote and could not return on the same day due to her illness the semicolon that on the next day, the accused number one sent his younger brother to bring her back, after which the alleged cruelty on the deceased intensified. It is full stop here. It is alleged that on 16/4/2026, being unable to bear the torture, the deceased consumed poison with suicidal intent. The accused persons allegedly concealed the incident and provided her secret medical treatment and threatened to break the marital tie if the matter was disclosed. It is alleged that when her condition deteriorated, she was admitted to Gwalpara Life Care Hospital on 26/4/2026, where the doctor confirmed poison consumption and the deceased narrated the alleged cruelty to the informant. It is alleged that thereafter she was shifted to Dispur Hospital in Gauhati on 27/4/2026, but she was discharged on 28/4/2026, taking into account her condition, as there was little hope for her survival. It is alleged that the deceased passed away on the way back home. Full stop. On the basis of the FIR, police registered Gusaigaon PS case number 131/2026 under section 85/108/351(2)/3 of BNS 2023. Mr. A.W. Aman, the learned counsel appearing for the accused applicant, submits that there is no cruelty on the part of the accused applicants as alleged in the FIR. He submits that the deceased was in fact not happy with certain behavior of the accused number one, and on the spur of the moment she consumed some poison. He submits that immediately thereafter she was taken for medical treatment and ultimately after visiting few hospitals, after spending some times in different hospitals, she was ultimately taken to Dispur Hospital in Gauhati, wherein she was discharged, and on the way back she died. He submits that there was no fault on the part of the accused applicants, and the accused applicants had given whatever medical treatment required by the accused applicants. He further submits that the instant FIR has been filed after almost 55 days of the alleged incident, which is unexplained. He submits that in view of the aforesaid, the accused applicants should be granted PRS bail. Full stop. On the other hand, MS SH for underlined APP submits that the accused applicants have started harassing and torturing her immediately after the marriage, and when she consumed poison, she was already 5 months pregnant. She submits that the learned APP submits that taking into account the fact that she was already pregnant, and the mental condition of a mother cannot be such that she would commit suicide when she was already carrying a child. Full stop. Then you write, CD in the instant case has been produced and the same is perused. This court has considered the submission made by the learned counsel appearing for the accused applicant, also the learned APP. Full stop. This court has also perused the case diary that has been produced before this court, and after finding sufficient incriminating materials, prima facie sufficient incriminating materials against the accused applicants, accused applicants, and taking into account like the sufficient materials, this court is not inclined to grant any relief to the accused applicants at this stage. According to the instant AV application is rejected. CD to be returned.
May I please. Lordship, it's an anticipatory bail application.
Charge sheet has been filed already.
Item number 14, madam, we did receive the madam CD.
No, I'm told that like morning it was told that charge sheet has been filed.
Part charge sheet has been filed, Lordship. There were two accused person. The present accused.
You don't have any instructions.
Madam, and madam, the phone.
Take the instructions for what has happened. Take it out.
48.
May I please, your lordship? It's the second time bail application, your lordship. The first bail application was rejected on 2025, your lordship, at the investigation stage.
Where is that first bail rejection?
It is on page number of my petition and page number 19, your lordship.
Yes.
The petitioner is behind the bar for 474 days till today, your lordship. Behind the bar, he is behind the bar for 474 days till today. The charge sheet was submitted on 22/01/2026.
22?
22/01/2026. The case is still on pre-trial stage, your lordship. And last week, the other co-accused were released on bail.
Co-accused released on bail. Where are the orders?
Your lordship, it is on 14/8/2026, but I could not collect the certified copy. I have taken it from online. Your lordship.
When it was granted?
On 14/8/2026.
14/8.
Yes. And due to vacation, I could not collect it from Passer.
14/8 means recently.
Recently.
Yes.
I have filed this present petition on several grounds, Your Lordship, but I argue especially on 4 grounds. Number one, my first ground is detention beyond 24 hours, Your Lordship. My second ground, non-compliance of section 48 and 36B BNSS. Number 3, long detention, Your Lordship. And third is the chain custody is broken. On regard of my first ground,
No, but
detention,
non-compliance of
non-compliance of
non-compliance of?
section 36B and 48 BNSS. Your
and 48.
48 BNSS.
Third ground.
Third ground, prolonged detention, Your Lordship.
Fourth ground.
Fourth ground, chain custody is broken. Chain custody is broken. That means the primary evidence, it's already in doubtful condition, Your Lordship. The FSL report, that means.
No, what is your ground you said?
Chain custody is broken.
Chains custody?
Yes, Your Lordship. On the primary evidence, the sampling, on sampling.
Chains custody?
Yes.
What chains custody? I could not understand.
Not chains, chains. Sorry,
What?
Your Lordship.
Okay.
On regard of my first ground, I want to submit the time summary first, Your Lordship. Intercepted at 12 noon on
Intercepted.
Intercepted.
When?
On 12 noon, 0105.
At 12 noon.
On 05, on 01, Your Lordship, sorry, on 01/05/2025.
At 12 noon.
Arrest memo prepared.
Arrest memo?
Prepared. On after 22 hours on 02/05/2025 at 10 a.m.
Then?
Timing of medical examination is 1 p.m. on 02/05/2025, which is already beyond 24 hours.
Produced when?
It is not mentioned in the
order,
report.
on the order. Magistrate must have passed an order, no?
Yes.
Then?
In the order, it is mentioned on between 4 p.m. to 5 p.m.
One, 2, 5.
Yes.
Yes.
The place of
Where is
arrest.
the order? Where is the order? A magistrate protection before the magistrate?
The magistrate, not in the magistrate.
Where?
There is no order, no such order of timing.
Produced before whom?
Produced before magistrate, but magistrate did not mention.
So where is the order I want to see? You have not annexed that order?
No, Your
Why?
Lordship. I have missed it, Your Lordship. I apologize. I have missed it, but I collected from the 230, the copies of 230 that is.
No, the magistrate order will reveal everything, no? What is there, what is not there.
Yes.
That should have been on the record.
I highlighted that the timing the medical after medical examination, he is produced before the magistrate, but there is no time mentioned in the order, your lordship.
Four to 5 PM from where you are saying?
I have seen the last bail order. Last bail order.
No, last bail order, I mean, it must have been stated by the council only on the basis of that.
I'm not stated that is the appropriate time.
That,
That is that.
no, how
I rely on the medical examination report, your lordship.
medical examination, you said that it was done.
At 1 PM. I have annexed that.
So 1 PM medical has been done. Then how you have presumed that it produced before the court at 4 to 5 PM?
That I withdraw that. I withdraw that submission, your lordship.
Sorry?
I withdraw that submission. I highly apologize, your lordship, for that. I missed.
You argued last time.
Huh?
Last time you argued the matter when the matter was rejected.
Yes, I am also there.
What is your name?
P. Seal.
P. Shield.
Yes.
Okay. Okay, you are also there. And this point was argued.
No.
Why not argued?
So this point was not argued, but before trial court, I argued this matter. Before trial court, I argued this matter.
Then what happened? Rejected?
Yes, it is rejected.
Where is the rejection order?
The rejection order is page number 59, your lordship. And here, the Honorable Judge of the lower court took the present production time at 1 PM, your lordship. But at 1 PM, he was in medical examination, your lordship. It was page number 64.
How much time it takes from medical examination from where he has done the medical examination to the court?
Yes, your lordship.
What is the time period it might have taken for the accused person to bring from that medical examination, wherever the medical examination is done, to the court? As per you, how much time it will take?
For medical examination, your lordship.
From medical examination to the court.
That is not mentioned.
So how you're saying that it is not done at 1 PM?
The medical examination done at 1 PM.
No, production before the court.
Because at that time I'm already undergoing the medical examination.
So, medical examination completed when?
Already as per
medical report was done at 1 PM, right? 1 PM medical examination?
Yes, medical examination is done on 1 PM.
That is what I am saying. Medical examination was done at 1 PM.
Obviously.
So how much time it will take from his examination to the place of to the court for production?
But obviously after medical examination,
obviously I understand it will take 15 minutes, 20 minutes, 1 hour, 2 hours, 3 hours. How much time it will take?
Yes.
That's what I'm asking. Are you aware like what is the distance of the medical center to that court?
It's 10 minutes here.
10 minutes. Then how can you say it's 4 to 5 PM? So within 10 minutes, that means maybe maximum 10:30, 1:30.
Now I apologize, your lordship.
No,
you understand the bail order.
No, I'm not asking about you. I'm not asking about that. I'm just asking, as per you, probably at what point of time The accused must have been produced before the court.
For me, it's on 4 to 5 because after all the case, as per fact, your lordship, when after all case is done, then the production is committed in lower court, lordship.
That presumption cannot be taken. From where you can say that like
I relied on the medical examination, your lordship, timing of medical examination, because from 12 to 1 p.m., next day 1 p.m., it is already beyond 25 hours. And same issue, same scenarios occurred before this for your lordship, and your lordship will discuss this, decide this ground on medical examination timing, your lordship.
where is the discussion by the trial court about the timing? About the timing, where is the discussion by the trial court
Timing.
about the production and that you argued about this point, right, before the trial court? Where is the discussion? At which page? Page 60, some mention is there. Then where he has discussed?
Page 63. Paragraph 3.
Timing, page 64. Page 64, your lordship. Page 64.
One second. And where was he intercepted?
From where? He was intercepted from the Bagha Bazar, Saipai Road.
Bagha Bazar, Saipai Road. Bagha Bazar, Saipai Road to the court. How far is it?
This 36 kilometer, your lordship, and it takes time 45 to 1 hour.
So 45 to 1 hour. So it is within this thing.
But at 1 p.m. he is under medical
The
examination.
accused was produced before the magistrate on 2520 p.m.
Not 1 p.m.
The-
As per medical examination.
Magistrate has, this court has recorded this.
But as per medical examination, your lordship, he is under at 1 p.m. he is under medical.
This is a judicial order. This is a judicial order passed by an additional session judge. He said that he was produced at 1 p.m. And how am I supposed to disbelieve him?
On the
Medical report, maybe there is some time here and there. Where is the medical report?
it is page number 74, your lordship.
74. So if it is done 1 p.m. and it takes 10 minutes to reach there from the medical center, that means like maybe by 1:10 he was produced. As per your this thing, 1:10 he is produced. So if it is 1:10, then taking into account the time traveled, time that will require for traveling from the place of arrest to this place, that time has to be excluded. If that is excluded, then it's 24 hours.
Then he has to produce before magistrate at 1 p.m.
1:10 p.m. he has been produced.
Not your lordship. At 1 p.m. he is in the medical.
I understood. That's what I am saying. Try to understand. I am saying that you are saying, I am not saying, you are saying that it takes 10 minutes from the medical center to reach the court. Then it's 10. Then if he was examined at 1 o'clock, then that means by 1:10 he was there in the court.
Yes.
Then it is within 24 hours. Maybe 5 minutes, 10 minutes. I can't be that, the court cannot be that hyper technical that 10 minutes delayed, 5 minutes delayed beyond 24 hours. So he should be released.
Timing, your lordship, but the timing excluded that from the place of arrest to to the court.
Correct. So to the court means, so time.
Place of arrest is your lordship, Bagha Bazar, your lordship.
So Bagha Bazar to reach medical center, how much it will take, the time it will take? You said 45 minutes?
Yes, sir.
So 45 minutes or 1 hour, that has to be excluded? The
Yes.
traveling time has to be excluded?
Yes.
So it from 24 hours, the time is excluded.
Yes.
Then what happens then? So you are saying that 12 o'clock he was arrested, right?
Yes.
So from 12 o'clock he was arrested. So if you minus 1 hour, the
Yes.
traveling time, that means just take it as 1 p.m.
Yes.
Then 1 p.m. he is arrested. Then if you count 24 hours, then 1 p.m. he was produced before the court.
But there is no record.
So that's what he showed me, that like he was no record means I mean additional session judge has recorded that he was produced at 1 p.m. Should I disbelieve him?
No, your lordship.
Then?
But at that time, at 1 p.m., injury report as per injury,
I understand. I understand. I am saying that like yes, he was there at medical center at 1 p.m. And it took him maybe 10 minutes, 20 minutes to reach the court. So maybe 1:20, 1:30 he was produced before the court as per your estimate. If he was produced at 1:20, then how much delay? Beyond 24 hours, 20 minutes delay as per your estimate. If it is 20 minutes delay, should the court be so hyper technical that if somebody is produced only 20 minutes, 20 minutes delay, he should be given bail on that ground only?
But the provision strictly said that
Provision strictly said 24 within
hours.
24 hours. That means like 5 minutes, 10 minutes. Also like if somebody is produced 5 minutes delayed also, then also he will be allowed. He should be granted bail for this kind of heinous crime.
But at 1 p.m., really I was out from the medical. That is also a question.
So how much time you will take? You tell me, madam, I'll take your time. How much time you will take from you yourself said that like it will take maybe 5-10 minutes from the medical center to reach the court. Then I'll calculate that time only 5 and 10 minutes. And the judicial and additional session judge specifically recorded that he was produced at 1 p.m. I cannot disbelieve him. You are showing one record, that is one document, that is a medical report. I take it as a correct 1 p.m. The 1 p.m. then another 10 minutes. 10 minutes he was produced. Maybe he was produced at 1:10 p.m. and additional session judge has written 1 p.m. Okay, we have taken 1:10 p.m. So do you want that like because 10 minutes delay in production beyond 24 hours, should I grant him bail on that ground only? For this kind of heinous crime, so much of narcotics have been seized.
But your lordship, same ground was arised before this court.
I understand, like we are aware of this, madam. We are handling this kind of cases every day. Every day we are handling these cases, in which cases 24 hours, how 24 hours has to be calculated. We are aware of this. We are aware of the what Supreme Court has said. On the basis of this, we are saying. Correct. Had it been like 1 hour delay, 2 hour delay, 3 hour delay, it would have been a different thing altogether. It's like maybe a question of 5 minutes, 10 minutes, I do not know, but I'll have to go according to whatever is written by the additional session judge, provided you can dispute that that no, this timing was not right, it was not rightly, rightly recorded, the time should have been this. I will agree, I will go with you, but provided you'll have to show me some document saying that, okay, no, he cannot be there at 1 o'clock at all. Because from the medical center itself, it takes 1 hour to reach the court. If you can show some document or you can provide me some material, then I can think about this. But you are saying that it takes 5-10 minutes. If it is 5-10 minutes, then he must have been produced at 5-10 minutes because they are not going to wait there unnecessarily. And I cannot presume anything. Whatever is there on record, I'll have to go by that. You understood what I'm saying? So, I mean, this point, I don't think there is any, because this has been rightly rejected on that ground. There are cases wherein 24 hours, see, this is a settled law. That is there is a statutory provision. You cannot go beyond 24 hours. You cannot. But court has to also see like how much time delay. If delay is 5 minutes, 10 minutes, half an hour, then court will see whether, whether court also has to place with some discretion. You have to see, what kind of delay. If it is an undue delay, then it's a different thing. But from your submission only, you are saying that it's, then it takes around 45 to 1 hour. Then we'll have to take that aspect into account. Then if you minus this, then it is within 24 hours. Then anything else?
Yes. My second ground.
Arrest memo. Show arrest memo. Where is the arrest memo?
The arrest memo is in the page number 67, Your Lordship. Of my petition, the arrest memo is in page number 67.
So arrest memo was, what is the ground on arrest memo? No witnesses?
Yes, Your Lordship. Yes.
No witnesses?
No witnesses.
Okay.
Signature of no witnesses.
And when is that for? Where is that 48 notification? 48 notice?
It is page number 73. And this is not a notice, it is a certificate. It is like a certificate, Your Lordship. And here, in this certificate, it is said that the arrestee, Sri Lallo Thoma Thek, has intimated his wife, SMT Ruipui, about his arrest by phone by himself on contact number on 10:20 hours on 02/05/2025. In this ground, kindly.
Mr. Kel, no notice was served? Notice was not given? 48 notice?
The 48 notice should be served by the police arresting officer, not by the accused himself, Your Lordship, as per section 48(1) of BNSS. Every police officer.
This was given by whom? Police officer, or he himself made it? This section 73 notice, section 73 notice, page 73 notice, which has given, who has given it?
It is not a notice, Your Lordship, it is a certificate. It
So
is given by the.
That's true. That's why I'm asking whether in a written notice was given. Now it's a certificate. It's a certificate means it's on record that person has been intimated. Correct. So intimated means our wife has got the information that he has been arrested. Right. So now that you have seen the latest judgment of the Honorable Division Bench of this court.
Yes.
As means section 36.
Yes.
So it has stated that section 36, if witness is not there, also family member is I mean, that's a kind of, I mean, that is the observation of the Honorable Court. If substantial compliance is there, then section when witness is, if witness is not there also, there is a compliance. So you can't say that 36 is violated. Any other point? But Mr. KL, 48 notice was given or not? Where is that? Page 73 is the only, I mean, only. 48, Mr. Kayal, I mean, it has been stated by Honorable Supreme Court in many cases that it has to be a written notice. To written notice, is it a notice? No. It is no sufficient compliance. I mean, whether a notice has been given or not to any of the family members. Please to see page 70. I have seen that. Below what?
Not signature.
Where is signature of wife?
I have been contacted by family member.
I have contacted
Signature of accused.
my family member wife.
My family member wife on her
Mobile number. This is the person who is arrested.
Recently, Supreme Court in case of state of Kerala versus paragraph 11 to 14, the stated sufficient compliance is
No, sufficient compliance means what?
there's no approximate please to see. State of Meghalaya versus Sonam Raghuvanshi. Where the claim was granted by paragraph 11. Where we find that the respondent is not entitled for bail both on merit on the ground of discussion by both the court. There is a fundamental difference between non-service of ground of arrest and non-furnishing of adequate reasons thereof. While the first category might receive the arrest, in the second category, one has to see the prejudice caused to the accused. In the fact, in the incident case, it is not as if the respondent was not served with the ground of arrest. And the case of the respondent found within the second category discussed above, the respondent has also not taken the safe plea at the earliest point of time, having done so only in her court bail application before this price. And paragraph 12. It is the respect of the contention of the Criminal Council for the respondent that there is no waiver of the right to granted under Article 21 of the Constitution. And therefore, the state in which the plea touching upon fundamental right is raised would not matter. We would only clarify that when and appeal person files and verification by state might become illegal. However, when the appeal person warranted a finding on merit on the earlier occasion, it is not open for him to go back and raise the plea and the issue pertaining to the ground of arrest thereafter. As reported earlier, the respondent has expressed her satisfaction for the reasons behind the arrest before learned division must prepare relevant document where deeds served on the respondents. Therefore, we are not inclined to go into the issue as to whether the court invoked the legally served by the respondent or followed by
So this is on a different basis only. This is on fundamental difference between non-servicing of grounds of arrest.
Here not the ground of arrest.
Grounds of arrest. No, it is not grounds of arrest here.
48.
For 48 asking for, I mean, notice to the, see, in the case of this, I mean, which was the case? Bihan Kumar's case. Not Bihan Kumar, the other ones. So, Here the case is like non-service of grounds of arrest and non-furnishing of adequate reasons they are under. So he says that like, I mean, first, if you are not giving the grounds, then it will vitiate. But in this case, the grounds were given. Grounds were given, but like no sufficient reasons were given. And another point was taken that like whether in the subsequent bail application, new pleas can be taken. I mean, on the same ground.
So what if in this case, four bail application filed by the
Correct,
police?
correct. Correct. So they have not taken those grounds earlier. So that's why the court said like this may not be open for them. However, when the accused person warranted a finding on merits on the earlier occasions, it is not open for him or to go back and raise the plea on the issue pertaining to grounds of arrest thereafter.
This is the judgment given by our litigants of our.
This I have seen, this I have seen. That is on a different ground.
No, this was referred by indulgence to the division bail. Consider as to whether bail, the condition of bail has been violated. That, sorry, ground of arrest has been.
This I am aware, Mr. Adit. This I am very much. I've just mentioned about this.
Yes,
I am aware of this.
Paragraph is 7E.
Now that I am aware of. What is there?
The prejudice will be having.
Then I'm not asking about this arrest. See, thing is that like this is a mandate that you'll have to give a written notice. So whether you have given a written notice or not.
Electronically is not informed. That was discussed by learners. Single file. Page 64.
See, one line totally goes against you without going to any other aspects of the matter. It says that, however, when the accused person warranted a finding on merits on earlier occasions, it is not open for him or her to go back and raise the plea on the issue of pertaining to the grounds of arrest thereafter. So once you file a bail application, if you do not raise these pleas and if you argue on the merits, subsequently you cannot. That's what the Supreme Court said. And all the bails that has been granted on the basis of this pleas, those will go.
Yes, your lordship, but as per section 483,
You can file a subsequent bail.
Subsequent bail, not that.
Mr. Kayal, you should read this paragraph and give me what is your opinion on this, because you should have, before arguing, she started arguing, you should have pointed out this.
Yes, your lordship, as per section 43, the BNSS, if special power of High Court or Court of Session is given and both powers are separate. They both the courts separately use that power, Your Lordship, not dependent on the lower court or high court. The concurrent power, Your Lordship.
Your bail was rejected earlier, right?
Yes.
By
but-
this High Court.
Yes.
So you did not argue that point earlier.
No.
And you are not understanding what I'm saying, what this court is saying. Supreme Court in this case has said, I'm reading it for you again. However, when the accused person warranted a finding on merits on earlier occasions, you argued the matter on merits and wanted bail. It is not open for him or her to go back and raise the plea on the issue pertaining to grounds of arrest thereafter. So it says about grounds of arrest. But it doesn't speak about other grounds also.
Also, page 64, London High Court trial, the verification has to find it and this one also.
No, her case is see, first of all, section 48 notice was not given. Arrest memo, okay, we take it that I mean substantial compliance because I mean intimation was given. But what about, but these are all independent sections. For 48 notice, where is 48 notice?
This point was raised before the London session judge. And London
Session just forget.
No, just question.
Now thing is that 48 notice, where yes, let us read what session judge has observed. Which page? Page
64.
64. Yes.
Last time. The maintaining of ground of behavior. In the notice only, so the arrest memo, the notice does not mean, cannot be safely the ground of behavior is not provided. The information to the committee members, what the sound cannot said to be in violation of the legal provision as because when admittedly the persons to whom information is to be given, get Gauhati. The person who had said the child is not possible to travel to Gauhati. If you know the judgment relied upon in this case, it's Mr. Prahan, assistant of Assam, in which the honorable Gauhati High Court has discussed about the notice sent through the message, where there was no reply to whether the message was properly contained, but in the state case, admittedly the message was contained about form. And as I said,
But Mr. Kyle, you were aware of those cases, Ernest Kumar and all. Then what is written there? Notice has to go in form.
Currently, our High Court also said that and the communication through telephone or even WhatsApp message that
WhatsApp, you send a WhatsApp with the notice photograph, that's a different thing. But telephonic information is compliance. You show me a case
that is in by our High Court.
Where telephonic compliance is, I mean, section 48 notice, it was specifically written by in the case of Bihan Kumar that it has to be a written notice and that too providing the grounds of arrest. Where have you given the grounds of arrest?
He was informed or telephone by her.
Where are the grounds of arrest? Informed about the arrest only.
I think police has judgment before telephone communication is sufficient.
You come back, I mean, I have heard you substantially, but I don't want to just pass an order just like that. You can prepare the case properly and we'll put it some other date. Both of you. This Suryavanshi case also you see properly what will be the effect, because it says that a plea cannot be taken later on. It says that once the bail is argued, bail petition is argued on merit, the plea of grounds of arrest cannot be taken later on.
Section 48 is to inform the pending members so that they can approach the court for seeking plea.
That we understand, but Supreme Court has said that that in Bihan Kumar state, I mean, Justice Koteswar Singh has written a paragraph on that.
It is dedicated to that purpose, but subsequently in other judgment, that plea has been diluted.
No, where it has been diluted.
Today I have not. Repeated judgment.
Sridhar's case, somewhat it was, but it was in a different context little bit.
Not being different context, but SI's case. Subsequent cases, lot of this plea has been somewhat.
You come back with all the cases because this has to be decided on the joint prayer of the joint prayer of the council appearing for the parties. Let the matter be listed on when 16 September. 16 September. Mr. Kyal, I am just keeping this, this Sridharsan.
Lordship. I give it for your lordship.
Okay, I'll just keep it.
Regarding other judgments, I'll complete.
This one I have, you can keep it. And madam, you take this, madam, you take this order. And this one also, Vishal. तीनटा बजट में 5 मिनट लगेगा ना, बड़ा बेटा तीनटा बजट.
I was informed that he was supposed to send my lord status, so we basically stated that my lord, because they had my lord not able to, my lord, the accused petitioner not able to appear before the IO physically, but partial taken my lord statement and other parts rest my lord still there my lord. And because of the my lord that unfortunate incident of my lord that assigned opposite task my lord, they are in Kaplong my lord, they have to be there, but also pay for a 1 day accommodation. The detailed report will send them on the spot. In this case, my
No, virtually they have appeared.
my lord actually appeared my lord, but he said my lord that statements yet to be my lord take my lord important.
Part statement has been taken on this Sunday. Part statement has been taken on this
But it's not
Sunday.
complete.
Part,
So he appeared, then we will give them some time.
yes.
Okay.
Gotcha.
On the prayer of learned APP, let the matter be listed when.
Any day my lord, he prayed for a 1 day my lord between my lord report and a few weeks from this.
25th August.
Fine.
25th August.
Yes, gotcha.
Your name is Jedas.
Jedas.
MS Jedas is present for the
Okay.
accuser.
Prohibitions.
This matter will kindly be taken up to some time. Mr. Kumar will appear in this matter. Up to some time, Lordship.
Who will appear?
Mr. BD Kumar, Lordship. Mr. BD Kumar, he's on lakhs now.
After some time will be difficult. I mean, anyways, we are passing it over for time.
Night.
Lordship, the case will conduct by Mr. T.J. Mahathur. So he is in Lake in court number 1, Lordship. So another date, Lordship.
We'll exonerate, I mean, when do you want?
You did in first week of September.
It's a short day because of this case, otherwise we will not object to the petition.
You will not object to the petition.
No, that's what had happened, my lord, in this case. Initially, there were multiple accused persons who were facing the trial. Subsequently, 7 other persons were brought in by 319 CRPC. Out of those 7, 3 persons approached this honorable filing a criminal petition, and this honorable court was pleased to grant them a stay. So that stay was in force. While that stay was still in force, because this matter had not been listed for a long time, the trial court issued MBWA against these 3 persons against whom there was a stay. So against that order, the petitioners have again come before this honorable. Well, since there is already a stay, so that order of issuance of MBWA is per se illegal. But now what has happened, because that order has been stayed, the trial in respect of the other accused persons has also stalled now. So as far as the issuance of MBWA against this person,
Yeah, you don't have any issues on that.
we don't have issue. Let that be quashed now, and let the trial court proceed with the trial of the other accused.
Then we can pass that order.
That was kind of civilian revision petition, I think, for 2019. And my lord, that is the last order, my lord.
That's a different criminal revision.
Yes, different criminal revision petition, my lord. For the last day of this, my lord, the order was, last order is my lord 26/3/2021.
Ah.
My lord, this period, my lord, which my lord, after seeing the petition, my lord, 2021. That is to be listed in the interim order passed earlier will continue, my lord. When my lord, the line is, the report, my lord, my lord, right, is the passing the order. So it is 2021, my lord, after the entering unification. Now 2026, my lord, because of that, my lord, the order.
NBW was issued.
On the matter, submission is the 2019 matter is there. That may be listed. We have related to this matter only.
Well, in that case also we have filed Wakalatnama. In that case also we have filed Wakalatnama recently. So once this gets disposed of, my lord, we'll also claim for listing of that matter. So we'll also be contesting that matter on merit. But here, since the only issue is the issuance of an NBWA, while a stay was in operation, so we have to concede, my lord, this order may not stand in legal scrutiny.
Okay, we'll post it some other date and he's not there. He's not there. Then on the prayer of the learned counsel appearing for the petitioner, which is not objected by the learned counsel appearing for the Mrs. Nawaz learned counsel appearing for the respondent, let the matter be listed on.
But it's a short date because the trial is at the last stage.
26th August, 26th August. And record his presence also, Mr. Bush, okay, Bush. APB. Interim order so fast order is continued.
Item 10.
Serially matana. Serially matana. No, because of the copy preference developer house. If you do a passport, so you have to key on prices. itu tuh passport করছিল 10 to passport করছিল 11 to হয়ে গেল নাকি 11 to
কোন পেজ
Yes.
Well, on behalf of the victim, my lord, the name appears in the cause list.
The service report is complete.
Yes, my lord, even.
Huh? Who is appearing? Who is appearing? Who? POCSO matter.
I Ali.
Where is I Ali? I mean. Mr. Kumar will have to wait for some time. Let's see whether he comes. If he is not there, then we'll have to postpone it.
My lord, may I please, my lord, for 26th of August, my lord.
26 will be difficult.
Because, my lord, the next date is fixed for IO on 3rd. So.
Okay, let it be on 28. Sorry. You are saying when? 3rd.
26.
Okay, let's try and so 26 is on Wednesday. Let's put it on Thursday, 27.
27. Yes.
27.
Also, item number 8.
Okay. Item number 8 also you are praying. Okay.
We receive the
27.
Okay, 8 and 1 second. 8 and 10, huh? 8 and 10, both on the prayer of Mr. BD Kaur, the senior counsel. Let the matter be listed on 27th. Both the matters 27. Will take time, both the matters.
No, the short matter, well, application file for recall.
Other matter?
Other matter, little bit time, but we'll manage.
Okay, 27.
Inconvenient.
CD written, 27th.
May I please, your lordship? Lordship, this instant criminal petition has been referred against the order dated 26th March 2026, whereby, your lordship, the Zimma petition was rejected of the petitioner. Lordship, the petitioner is a businessman by profession and he runs the business of coal and stone, your lordship.
During that, your lordship, some dues were accumulated and he had,
Report has come. Why report is not receiving all the time? Earlier also time has been taken.
yes, your lordship. Other than that, your lordship, the investigation in the case has been completed. The amount is lying in the treasury, your lordship.
One?
It's lying in the
How
treasury.
much, how much money?
48,76,000, your lordship.
Huge amount of money lying. Okay, your name?
P. Upadhyay, your lordship.
Third MSP Upadhyay and counsel for the petitioner also have Mr. KK Boyster, learned AP for the state. Mr. Boyster submits that the report relating to the amount seized in connection with PRC case number 6492026 is yet to be received. He prays for a short accommodation. Let the matter be listed on
Next Tuesday, your lordship, if possible.
no, next Tuesday, no question. Okay.
27 minus the report will be received, man.
Huh?
The report was not.
Okay, we'll put it on 7th September. Yeah, question. I'll just come in 5 minutes, huh? Just 5 minutes.
Mana ki oh. Oh. Vacations and itu kulit lagi kulit. Boleh sana coba. Berapa? Graduation. Hah? Oh, itu kan mereka. Dalam tempat fisher pun tak. Apa yang sulit? $25. Itu bisa, nah, Party borders.
Today I have filed my power. For the response number 12.
None appeared for the petitioner when the matter was called for. TCR received, TCR. TCR received. Mr. A. Chetri has appeared on behalf of respondent number 2 and 3. Let the matter be listed for admission after 2 weeks.
35.
I was convicted under section 376 and sentenced to undergo imprisonment for 10 years. There is the IA for bail, Lordship.
Written objection state. Huh?
And in this case, Lordship,
IA is for what? Bail.
bail. The
Objection not filed. When you're taking so much of time.
The victim, your Lordship, the victim has died, so she could not be examined. The prima facie, there is no material in the substantial evidence on record. All the witnesses examined, neither the doctor was examined, neither the judicial magistrate, nobody was examined. 2 informant and 3 independent witnesses were examined, and all of them alleged to have been reported witness. And there is
Let the objection come. Okay. Heard Mr.
Jadalov.
Jed Alam, the London Council appearing for the applicant, also heard Mr. K.K. Boyce, London APP for the state. Mr. Boyce submits prays for some time to file the written objection. See, last time it was said that like it was submitted. Then it was not on record. Then it was to be verified by you. S.H. Bora was there. You find out, we'll post it somewhere.
Date may be fixed, Lordship.
Uh,
No.
Let the matter fixed on 9th September.
Diploma. 9 September.
I think it is not filed probably. Because of that, it's not on record. So you file it. You file it.
37.
May I please your answer? The FIR is it page 19. Is what has happened in this case?
Office note C, order C first. It is come for orders, not for arguments.
I'm paying for stability.
TCR has come. TCR not received.
Yes.
Then why are you arguing?
Otherwise, if you see it was the order of the 20.
That respondent number 2 has not received the notice. Then why are you arguing?
It's a completely civil case, man. And the respondent.
Forget about this. I mean, now the notice has been issued and TCR has not come. You should check the record.
Thought that we
Mr. D.K. Agarwala is present for the London Council. Mr. D.K. Agarwala is present for the petitioner. Office note dated 14/8/2026 reveals. See, you'll have to take a fresh steps probably here. Reveals that notice issued upon respondent number 2 has been received unserved with postal remarks. In quotation, you write refused, comma, no such person on address. No such person on address. You verify the address and take first steps. The learned PCR is yet to be received. The learned counsel for the petitioner submits that he should be allowed 3 days time to file to take first steps in the instant case. Type pair is allowed. The counsel for the petitioner shall take first steps for service of notice upon respondent number 2 by way of speed post within 3 days. Let the matter be listed after 2 weeks.
Let's just my one request. Let's see the order of 27. It said that the interim may be considered at the returnable date. So if that may be observed, that interim can be considered at the returnable date.
That order is still there. That has not been vacated or modified.
Yes.
That still remains.
Great. Date may be given.
Okay, 11th of
Grateful.
September.
49.
My lord, in this matter, the counsel, Mr. Anjad Chaudhary, is due to his some personal difficulties, could not able to come today. So my lord, kindly pass over the matter for the day.
You are there in the case.
Yes, my name is also reflected.
But you have not taken steps as yet.
That, my lord, it is in hearing stage, ma'am.
What hearing stage? This has come for the order.
13.
Oh, this is a hearing. Item number
49.
49.
49. Sorry. I have heard it's 39 is being
Okay,
called.
okay. 49. None appeared for the petitioner when the matter was called for. Service is yet to be completed. No, service is office note dated 23/7/2026 reveals that steps for service of notice upon the respondent. 1 second. Steps for service of notice on respondent number 1 and 2 is yet to be taken. Let the matter be listed after 2 weeks. 3 weeks.
May I appeal about? My lord, the service I have consulted my office note service report is awaited in respect of respondent number 2. My lord, only my one humble submission that my lord hearing we are challenging and proceeding my order passing a 125 proceeding, my lord. On the earlier occasion, honorable court has given an observation that after my lord receipt of notice that interim order will be considered. Considering this aspect, if possible, lordship may kindly give an observation that after my lord that service of notice interim order will be considered, my lord. And my lord, the record has not been followed.
No, this is already, he's already observed here, where there is no further observation is required. Service report is awaited. Mr. So-and-so is present for.
Well, record may be called for. Record
the
was not
petition.
called for in this case, ma'am. PCR may be called for.
Okay, registry to call for the TCR. Scan copies of the TCR in which court?
My lord, please, sir.
TCR. In connection with
CJM Chief Judicial Magistrate Dhemaji on page 14.
in connection with Miss case in bracket CR case number 21/2029 from the learned Chief Judicial Magistrate Dhemaji.
Right.
Let the matter be listed after 2 weeks.
Obliged.
81.
May I please lordship? Lordship service report is awaited under respondent number 2. Service report is awaited.
Okay, MS so-and-so is present for the petitioner. Office note dated 14,820. 14,820, no, this is 11, should be 11,82026. Reveals that service is still awaited.
Lordship, kindly date may be
Let
fixed.
the matter be fixed on 15 September. 15 September.
52.
Yes, please, Your Lordship. As per office note dated 26/5/26, Your Lordship, the service upon the respondent has been complete, Your Lordship. The wife of the respondent has received the copy, Your Lordship. It is marked as flag X. The notice
Okay, MS so-and-so is present.
kindly matter fixed for admission, Your Lordship.
As per office note dated 26/5/2026. The notice has been served on respondent number 2. In view of the aforesaid services complete in the matter, let the matter be listed for admission in usual course.
Deeply obliged.
53.
Yes, we support everything.
Services awaited.
I waited, my lord, postal check report is not there, my lord, as per my information, my lord. I already received. But postal check report is not there.
Mr. A.J. Atia, Land Council is present for the petitioner. Office note dated 17/8/2026 reveals that neither AD card nor any unserved notice in respect of respondent number 2 has been received back by the section till date. Let the matter be listed after 2 weeks. After 2 weeks, you contact the registry.
My lord, the IA is there.
Registry to verify the postal track record and submit a report.
IA case is there.
Hmm?
One IA is there. IA. IA for staying, proceeding and supplying of
It will come with that, it will come with that, the
Supply
notice
of-
is served.
record.
Huh? Record is not called for earlier.
Record is with lordship, my lord.
Hmm?
I have no record at such. All record has been seized.
TCR is received, TCR is received. TCR is received.
Received.
So we have directed the registry to verify the postal record, track record and submit a report.
Date maybe.
Let the matter be fixed on 17 September. 17 September.
Make it to on first week, my lord.
First week it will be difficult, lot of matters are there. 14th of September. Legislative verification.
Really?
Huh?
They will seek time. They could have told the.
You should have told
Ah.
him.
Then I am.
Who is your senior? Pallab Kotaki knows Mr. Agrawal.
No,
Pallab
Mr.
Kotaki
Sisi my lord, I have been told Mr. Sisi Datta has been engaged as senior counsel to argue the matter.
Okay.
And today I have met him, he says that he will argue. But they could have made him answer, my lord, I have no objection, but whole day I am sitting here, my lord.
Yes.
That's the only thing.
Now you are appearing for whom? P. Kotoke. So Mr. Kotoke is not going to appear anymore. Or he will be the counsel. Okay. Okay. Your name? Okay, Mr. K. Agarwal, the learned senior counsel, assisted by so-and-so is present for the petitioner. Mr. N. Kashyap, the learned counsel, appearing on behalf of Mr. P. Kotoke, the learned senior counsel, submits that in the instant case, another senior counsel has been engaged and therefore there, and therefore, she prays for some accommodation. Let the matter be listed on when?
The 3rd of September or 24th or 29th September, any day. If they have
24th
some
September,
convenience,
24th September.
24th,
Third, there are some matters of
24th.
24th September. Let the matter, as agreed by the learned counsel appearing for the parties, let the matter be listed on 24th September.
39.
May not kindly pass over the matter for the day because the conducting counsel, Mr. Anjad Chaudhary, is not able to present.
Who?
Anjad Chaudhary, madam.
Anjad Chaudhary.
He is conducting this matter.
Your name?
N.M. Azarbian.
Mr. N.M. Major, we have the learned counsel appearing for.
Yes, record number.
Hmm.
The original transport record has been forwarded to me. There is no stay order. Original transport record is forwarded to the Judicial Court, and it is 9 months before the Judicial Court. So my humble concern, let the scan copy be shared.
Both submitted, both are forwarded.
Yes.
Scanned and, I mean, original both.
No, send back. Temporary file.
Oh, no, you are saying that the scan copies will be called for.
Scan to maybe kept. So the entire record is before the Judicial Court.
Okay, the registry will keep it.
That will never be.
Okay, okay. Mr. So-and-so is present on behalf of
Mr. Anjad Chaudhary.
Anjad Chaudhary, the learned counsel appearing for the petitioner. He prays for some accommodation as Mr. Anjad, Mr. So-and-so is indisposed today. Mr. Ajay Burwa, the learned APP submits that original case record, the original trial court record has been received in the instant case, and there is no stay order in the instant matter. Therefore, he submits that the original, he submits that that original case trial court record may be sent back by keeping the scanned copies of the trial court record. In view of the aforesaid submission, the registry is directed to make a scan copy of, make a photocopy. Photocopies, make photocopies of the trial court record and keep the same one record of the instant case. And the original trial court record may be sent back, shall be sent back to the concerned court, that is, which court? Nobody which court? Chief Judicial Magistrate. Chief Judicial Magistrate Nalbari. Let the matter be fixed after. CGM Nalbari. And let the matter be listed after how much time? 3 weeks.
Hearing matter, hearing.
Obligement.
Let the matter be listed in usual course.
May I please, my lord? This is a revision petition against concurrent finding because both the trial court as well as the appellate court has held that I am guilty of committing an offense under section 138 of that I am guilty of committing offense under section 138 of the Negotiable Instrument Act. As per the last order of this honorable court, my lord, I am supposed to bring an instructions whether there could be a possibility of compromise and remaining amount has been paid or not. Because the compensation amount is 5,50,000, and out of that, while the revision petition was admitted by this honorable court, 1,50,000 has been paid.
20%, how, what percent, how much percent?
Maybe exactly what percent that I'm not sure, but at least
But
1,50,000.
statutorily, how much is to deposit?
Minimum of 20%. Minimum of 20%.
Minimum 20%.
Minimum of 20%.
So you must have paid 20% only, or what? More than that?
No, my lord, around 20% has been.
More than that, then?
Maybe more
Yes,
than that.
yes.
Now, my lord, thing is that Throughout this time, I'm trying really hard to pursue my client to pay the remaining amount. But he said that there is no liability on his part. So I requesting my lord to fix a next date. On next date, my lord, matter will be heard and disposed of.
Also, they cannot see the order dated 9/11/51. Because of the voluntary declaration from the side of the.
9/11,
9/11/51.
20, 21. What is that order? No, I mean, those orders have gone now. Now the thing is that he's ready to argue the matter.
Yes, sir.
Only thing is that he's asking for some time.
Yes, sir.
That is what.
9/11/51, my lord, he has made a voluntary declaration that he is ready to pay the payment. Only for some time. Required. So she is 21, my lord, this is 26.
You have taken sufficient time.
My lord, I have taken sufficient time. I'm not making any excuse before this honorable court. But can this matter disposed of without hearing? My lord, that is the only thing that I'm.
No, you should.
Wonder-
Why don't you pay the remaining amount?
No, my lord, I have made all possible effort on my part to convince my client.
Okay, heard Mr. B. Decker, the learned counsel appearing for the petitioner, also heard Mr.
Canada.
and Alam, the learned counsel for the respondent. Respondent number?
Respondent number 2.
Respondent number 2. Respondent number 2, Mr. B. Decker, pays for some accommodation, which is not objected by the learned counsel appearing for the respondent number 2. Let the matter be listed. Listed. 16 September.
16?
September.
Deeply obliged, my lord. On that day, my lord, we will do our part. We will do that.
What do you want?
May it please your lordship. This criminal petition has been filed for crossing of the criminal proceedings of CR case number 79 of 2011, lordship. 2017 and cognizance of taking cognizance order dated 27/3/2017, lordship. In this case, what happened, lordship, the respondent number 1 has filed a complaint.
1 second.
Lordship. File a complaint. That complaint is I have annexed. Uh, 14, page 14, lordship. That is the type copy, lordship.
1 second. Yes,
Page 14, lordship.
page 14.
Yes, lordship. That is the type copy of the complaint, lordship. Filed on lordship 15/2014. So may I read, lordship? The complainant begs to submit as follows.
Yes.
Yes, that on 24/4/2013, while accused number 3 came to give possession of the suit land in compliance with the order of the civil judge, Borpeta illegally entered the house of the complainant, demolished the pakka and CIC roof house of the complainant situated on the land over which complainant has right, title, interest, and possession by misusing the power of his office following an illegal transaction with accused number 1 and 2 and furtherance of their conspiracy, and consequently the complainant suffering a loss and damages of rupees 1,50,000 rupees. It is therefore prayed that your honor to be pleased to get an investigation done by the officer in charge of Patasarkuchi PS of the award necessary punishment, so and so on. So this complaint is filed, kindly see, complaint is filed on 15/2014, lordship. And the incident took place as per the complaint.
1 second. 1 second. 15.
Yes, lordship. 15/2014.
Where is the date?
Lordship, it is in the page number 16 in the type copy and in the
It was filed on 2/3/2014.
yes, Lordship.
Huh?
15 to 2014, Lordship. And in the vernacular, Lordship, page number 19. Number 7 in the left side below column, Lordship.
But the case was registered on 2/3/2014, right?
Lordship, actually, that complaint has been forwarded to the police and the police has registered the complaint on 2/3/2014. Yes, Lordship. But complaint was filed on 15 to 2014. My point is that, Lordship, the incident took place on 24/4/2013. That is almost 10 months prior to the incident. After the incident took place, after 10 months, they have filed the complaint, Lordship. First thing, Lordship. Next, Lordship, why these things happen? Because of there is a title suit, Lordship, for possession of actually they are brothers. Petitioner number 1 is the elder brother and the respondent number 1 is the middle brother. And the case is between the smaller brother. That is, Lordship, I have annexed the title suit, Lordship. That is judgment is annexed to, Lordship.
Petition
and order is
petition is for petitioner number 1. You said petitioner is the elder brother.
yes, Lordship.
And respondent is the younger brother.
Younger brother. There are 3 brothers actually.
And the issue is with title suit is with
That issue is the middle one, Lordship.
middle one and whom?
That is a silent Sharma, Lordship.
Huh? Middle one and whom? Title suit between whom?
Petitioner and
Petitioner and
the
middle
case
brother.
is no in the title suit. That is the middle brother, but this case is with the third brother. There are 3 brothers, Lordship.
And a petitioner with the middle brother.
Yes,
Title
Lordship.
suit. And this case petitioner with the younger brother. Yes,
Yes, smallest, yes, sir. Narayan Sharma.
Youngest one.
Youngest one, Lordship.
Hmm.
Actually, they have ancestral property in their village, Lordship. And the petitioner used to stay in town, Lordship. And since they have not stayed together, they have illegally occupied his property, Lordship. That's why the petitioner, in this petitioner, approached the civil judge, Lordship Barpeta, for the recovery of possession, Lordship. That's why a civil judge, Barpeta, Lordship, in page 24, they have given the order for possession, Lordship.
Page 24.
Lordship. So page 24, Lordship. That is the order. That is the judgment's order, Lordship. Title suit number 11, title suit number 11 of 2011, Lordship. This is the type copy, Lordship, page 24.
Ellen Sharma and others means who else?
There are defendants, I am telling, Lordship, page number 44. Actually, Narayan Sarva, the respondent number 1 is the pro forma defendant there, Lordship, page 44, Lordship.
So Vaikuntha Sharma has filed this title suit against Soilen Sharma and others.
Yes, Lordship.
Others means
Mother and adult mother, not
who else is involved? Narayan Sharma is involved or not?
Lordship, Soilen Sharma, that is the middle brother, and Lordship, Srimati Kaisala Devi, that is mother, Lordship.
So Vaikuntha Sharma has filed this suit against his.
They are pro forma defendant 1 and 2, only Lordship Soilen Sharma, page 43, Lordship, against the younger brother. And there the mother and the respondent number 1 was the pro forma defendant. Page 33 and page 44 parties are there, Lordship.
Where is the type copy of this?
A type copy, yes,
43.
Type copy of 13, page 44. Yes, 38, Lordship. 38, Lordship.
So Narayan Sharma was also there as a
Narayan
performer defendant.
Their lordship.
Hmm.
And the FIR is filed after 10 months of the.
No,
case,
no, wait,
lordship.
then what happened?
Then we have.
Where is the order? What happened in the order? in
Yes,
this
lordship.
case?
Order is at page 36, lordship.
Page 36.
Judgment is at lordship page 27 and type copy I am coming. 27 and all. 70. Remaining photo title should judgment is page 27 written lordship.
Where is the type copy, madam?
Yes, lordship.
Page 21.
Yes, lord.
Judgment, lordship.
Yes, page 21 lordship. This suit coming for final hearing on 31/3/2012 in the presence of Mr. S. Sodhuri and Miss P.C. Das, so and so, so and so. And I have sued for consideration of this day. The court delivered
Okay,
the
come to
following.
the order.
judgment.
Come to the order, page 24. Plaintiff suit is
Yes,
declared
lord.
expertly with the
Page
question.
24, that point. Order, lordship.
Plaintiff.
Order, the plaintiff suit is decreed ex parte, which caused the following relief. The plaintiff right, title and interest decreed declared over the schedule B lane of the plaintiff. The plaintiff is entitled to recover the khas possession over C1 schedule land by evicting the defendant or any other person claiming through him, and also by removing the structures, if any, standing over C and C1 schedule land. Plaintiff possession over
Okay,
schedule.
okay. The C land is the land wherein this petitioner has gone and
Petitioner, yes.
petitioner has gone and he has uprooted that place or whatever. Is
That
it
is
so?
along with the Mondal, lordship,
Hmm,
with the court order, they have gone, they took possession, lordship.
Hmm.
After they filed that during this possession, they have, as per the complaint.
They have taken the position of the
Yes,
place.
yes, as per
Okay.
High Court order, there is a High Court also. I
Huh?
can next it.
They have High Court
High
order.
Court means not read declare directing handover possession, lordship.
Where is that?
Page 38, lordship. And
38 is something, 38 is civil judge's order.
handover report is lordship page 54.
Madam, what are you saying? You are saying 38, then you are saying 54. What?
Lordship, read directing the handover possession is.
No, which page?
Page 38 is read directing handover possession.
38 is what?
Read directing to handover possession.
38 is something else.
You know the difference also.
Madam, we come prepared, madam. I can't, follow like this. You please come prepared, madam. You come prepared. It can't be, you cannot follow like this. You say some other page and like mention something else. And,
They have, during execution, some demolition was done, the complainant was agreed with that. So he filed this complaint, case was, FR was submitted, then he filed Naraji petition. Thereafter, trial was taken, lordship, cognizance, after considering the statement of the witnesses and complainant.
you later prepare properly and like come back later on. On the your name, madam?
K. Pujari.
Huh?
K. A. Pujari.
K.
A. Pujari.
Pujari, the learned counsel, is present for the petitioner. You are amicus?
Yes.
Mrs. Chaudhary is, R.S. Chaudhary is, the learned amicus is present for the respondent. Present for the respondent. Let the matter be fixed on 24th September.
May I please your lordship? This appeal is against the judgment and order dated 21/12/2022, passed in session case number 30/17 under section 376(2) (1) IPC passed by the additional session
Yeah,
judge.
this is a jail appeal.
Yes, my lord.
It's for hearing.
Yes, my lord.
Where is the record? No paper book.
Paper book, my lord, this is a single bench paper book is not available, my lord.
But so much of records. Single bench paper book is not available. Who said so?
My lord, bench, when I asked for,
Say paper book is not required in this matter.
not served to us.
It's such a big, I mean, prepare a paper book. I mean, I can't be, I mean, done this also. These are all in vernacular.
Yes.
How it will be,
Yes,
how it will be read and done. Paperwork has to be made, all these things has to be translated. I don't know why it was not mentioned earlier.
My lord, this matter is pending for hearing. my
Correct.
lord.
Now, all these things are vernacular and cannot be read properly.
Yes, my lord.
Now, if paper book is not there, how the court is going to hear this matter? I don't know. Nobody has pointed out this thing. No, now it again it will. I don't know why. PP should have pointed out. Right, Mr. B.R. Sultana.
Yes.
B.R. Sultana is present for the appellant. MS S.H. Bora, Learned APP is also present for the state respondent. Trial court record has been received. It is seen that trial court record is voluminous and most of the pages and recordings are in vernacular medium. In view of the aforesaid, registry is directed to prepare the paper book of the trial court record, and accordingly, after the preparation of the same, the matter is to be listed for hearing.
My lord, that
in
may
each
be
case.
kindly given.
Hmm?
That may be.
Date
kindly-
cannot be given. Paper book, let the paper book be prepared. Paper book, after preparation of the paper book, registry will post it for hearing.
Assurance.
43.
This is for what?
Yes, this is an appeal filed by the CBI, your lord.
For what?
Against the judgment and order dated 31/12/2016. Your lordship, the matter, I have gone through the record, only case diary is there, TCR is not available. Though it is written, TCR is available because the matter is fixed for hearing. However, if your lordship will hear without TCR, then I am ready to proceed with. Without TCR, if your lordship will hear the matter, I am ready to
No,
proceed.
TCR, without TCR, how it will be?
Yes,
it
it
will
is
be done?
required. I have gone through the paper, only case diary is there.
Affidavit, you file affidavit, but it has been, TCR has been received.
But it is not available.
It's not there.
Not there.
Section রাখলে কেন ওটা আনবো লাগবো? The next date টা hearing টা evening টা section রাখবো লাগবো? TCR টো তাত কেন ডাঙৰ মানে কিমান ডাঙৰ? আপনি দেখান নাকি TCR টো নহয়? TCR one bundle, two bundle is not in section. TCR is there in the section.
Yes, probably it has been not sent here.
Okay, we'll put up some other date. Heard MSM Kumari, the Learned Standing Council, CBI. Also heard Mr. S.B. Laskar, the Learned Council for respondent numbers 1 to 4. It is seen that though the TCR has been received, the same is kept in the section and not sent along with the case record today. Let the matter be listed when
As your lordship, please, as per the convenient of the lordship.
2020. Let the matter be listed on the 22nd September.
Much.
22nd September. Hmm? उनका सेक्शन पठा दी बोलेगी that conclusion are not sent because registered it কি হয় wrong to okay it case record
45.
Wait, this is your lordship. I understand that this is the last item in the list, lordship. As such, I'm seeking for a short accommodation, lordship. As Mr. Das is on legs in another court.
who
Mr. B.D. Das, senior advocate, he's engaged in another court.
so and so the learning council appealing for the appellant submits that Mr. B.D. Das learning senior counsel is busy in another court. In view of the aforesaid, he prays that the matter should be adjourned. Let the matter be listed after 3 weeks. After 3 weeks.
Lordship, I have a small request. Given that he has been in jail for last 1.5 years, your lordship, considering that your lordship may kindly fix a short.
Not 3 weeks, not more, not before that. 3 weeks. This is a hearing matter, right?
Yes.
3 weeks. After 3 weeks, okay?
Very well, lordship.
3 weeks.